Please open the commission.
The Royal Commission is now in session. Please be seated.
Yes, Dr McAvoy.
Commissioner, we have handed to you a table setting out various documents which were put the day before yesterday to Mr Greg Holmes, but which were not tendered. One document that was put to Ms Mary Patetsis yesterday afternoon, and two documents that were put to Mr Joseph Rack on Monday and inadvertently were not tendered. So that we would seek to tender all of the documents in that list if the Commission pleases.
The documents on that tender list will bear exhibit numbers 2-62 to 2-75 inclusive.
If the Commission pleases. My learned friend Ms Hill will call the next witness.
Yes, Ms Hill.
If the Commission pleases, I call Ruth Harris.
Repeat after me. I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
will be the truth, the whole truth,
will be the truth, the whole truth,
and nothing but the truth.
and nothing but the truth.
Mrs Harris, could I ask you to please state your full name?
Ruth Harris.
And you're presently retired?
Yes, retired teacher.
And what's your age, Mrs Harris?
I'm 65.
And do you live in Adelaide
Yes,
with your husband David?
yes,
And you've got adult children?
yes,
You're the daughter of Joyce and the late David Edwards, is that right?
yes, that's correct.
And you're giving evidence today about your experience with the aged care system for your mother,
Yes, with my aged care.
and you've also got a mother-in-law who lives in residential care, don't you?
Yes, my husband's mother.
Operator, could I ask you to please display the document with ID WIT stop 0074 stop 0001 stop 0001. Mrs Harris, could I ask you to look at the monitor in front of you? You prepared a statement dated the 12th of March 2019,
Yes,
and do you see that statement before you on the monitor?
yes,
Are there any changes you'd seek to make to that statement?
no,
To the best of your knowledge and belief, are the contents of that statement true and correct?
yes, they are.
Commissioners, I tender that statement.
The statement of Ruth Harris dated the 12th of March 2019 will be exhibit 2/76.
As the Commission pleases. Mrs Harris, your mother was invited to attend with you today, wasn't she?
Yes, she was.
But ultimately she's made a decision that she's not going to come along today?
Yes, she was keen initially because she loves to do new things, but then she realised that probably health-wise perhaps she would get a little bit anxious and it might not be a good thing. Plus our time was changed to yesterday, and yesterday she did attend a friend's funeral and then changed back to today, so it's probably worked out that it's best that she didn't come.
How old is your mother, Mrs Harris?
She'll be 92 in May.
Could I ask you to tell the Commissioners about who your mum is?
So, Mum and my father and my brother and myself migrated to South Australia in 1966 as a family from South Wales. We come from South Wales originally. My mum was always a working mum back in the days when that wasn't as common as it is today, so she's always been a very active working person. My father died when he was 75 in the year 2000, so she's been widowed for the last 19 years, but she's always led a very healthy, active life, very active with her church community. very active in the U3A. Up until she was basically in her 80s, she would do folk dancing and a fitness class and always drove. She was drove up until she turned 90, so she's a very capable, independent, active lady.
Can I take you to the end of 2017? What was happening with you and your mother at that time?
Yeah, her health deteriorated that year. That was the year she turned 90. She says it's probably the worst thing that happened to her because her health certainly deteriorated. She'd always had some heart issues and blood pressure issues. She'd been on medication for both of them, but she started having unconscious collapses, and couldn't stand for long periods, and would get dizzy and really completely changed. She wasn't able to drive anymore. She needed help to do things around the house, which she'd never needed before. She'd always been pretty independent. So at that point, after she'd had a hospitalisation, we recognised that she needed some help at home.
So what did you do, Mrs. Harris?
So I rang the My Aged Care number and was told that that Mum needed to have an ACAT assessment, and so that ACAT assessment was organised, and that happened within a week. She had an ACAT assessment. She was assessed as level 3 medium priority, so that was in November of 2017. And so after that, we thought, okay, what else can we put in place? So at that point then, she decided to have some meals delivered, which she did privately through the independent living unit where she was living, also offered that support. Obviously you pay for it privately, and also cleaning once a fortnight. Initially she just had the meals 3 times a week, Monday, Wednesday and Friday, and we were told to wait to hear that she should get a package.
And were you in contact with My Aged Care over this period of time?
That first 6 months, Mum's health kind of plateaued out, and with those things happening and the support of myself and my brother, I started making up a roster for he and I so that we and I lived close by, so I nearly went every day anyway. So we kind of were okay waiting for a while, but then she had a further deterioration of her health about 5 months later, where I thought, no, I need to call My Aged Care again. She got quite ill.
And what did you do then?
So she'd been in hospital for a while. She came out and had respite, so I called My Aged Care again and said, look, we've been waiting for 6 months and we haven't heard anything, and now my mum's health has changed. We really need this package. And they said there's a 3 to 6 months wait for level 2 and 12 months for anything above. And I said, well, we've already been waiting 6 months and we haven't had anything. Oh, well, you'll just have to wait, kind of thing. So Mum came home from respite, and they said you could have help through the Commonwealth interim funding. So we accessed that by ringing a provider, and there's a certain amount that you're allowed on the interim funding. So Mum needed then help with showering and things like that. She needed a lot more. She needed personal care. She needed more help with everything. So we took the maximum that we could get through the interim funding.
And did your mother get the level of care that she needed on that interim funding?
No, even this was the maximum, which meant she could have someone to shower her 5 days a week, Monday to Friday, and someone came to take her shopping once a fortnight, and that was it. So I or my brother, we rejigged the roster, would go in and get her tea ready, and she privately paid for meals 5 days a week. And then usually I would provide meals on the weekend for her, or sometimes we'd buy those frozen ones that you can get. And that's when I thought, I need to start. So I would regularly ring My Aged Care as probably about once a month. And each time I got the answer, no, it's 3 to 6 months and a 12-month wait. Well, by this time we'd been waiting 8 or 9 months. And I said, well, we've been waiting this long and my mum's needs are really, you know, greater than what they were. And I would get the same response every time. So I would say, could I please speak to your supervisor? So I'd be put on to the supervisor and I'd explain that we'd been on the waiting list for some time, and he would say, or she would say, there's a 3 to 6 month wait, the same answer. So I said, well, is there anything I can do to expedite the process? Oh, you can make a complaint if you wish. So I said, yes, I'd like to make a complaint, please, and was given a complaint number, which happened twice. There didn't seem to be any further action regarding the complaint number. After the first complaint number, I had a call about a month later saying, you made a complaint. I said, yes, I'm complaining about the wait time. And they would say, oh yes, it's 3 to 6 months for a level 2 package and 12 months for anything higher. And I'd say, well, we've already been waiting now 10 months. Oh, well, sorry. So that went on for probably about 5 months after her second ACAT. So she had another ACAT at that point.
Did you make any further complaints?
Then I decided I would try writing to the minister. So I wrote to the Minister for Aged Care. I wrote to my local federal minister, and I made an appointment to go and see my local MP as well.
Was it always you that was calling My Aged Care?
Yes, it was.
So would your mum ever call instead of you?
No.
And
No,
why was
Mum
that,
didn't
Mrs.
call. I guess she felt, I think she felt I was probably doing a good job, but also it's difficult for elderly people. My mum's not deaf, but she still finds phone calls sometimes a little bit difficult to manage in terms of hearing the people, or they use language, the jargon, that people are often unfamiliar with as well. You know, it's a system that none of us have navigated before. I've got to say, it's kind of those where you learn on the job, because you don't know what to expect when you first get on the list for My Aged Care. I think I quite naively thought that once Mum had an ACAT assessment and the assessment said, yes, your mother needs support with this, this and this, that then that support would be forthcoming relatively quickly. So, and obviously that didn't happen. It comes to basically a dead stop once you're on the list.
Did you ever access My Aged Care online?
I looked at the information online, but I didn't communicate with them online. I communicated by phone.
And why was that, Mrs. Harris?
Because I feel better talking to a real person rather than typing. So yeah, that just suited me better, I think.
Was there any assistance available to you or your mother in using the My Aged Care?
No. It's just, you know, talk to someone and see how it goes. I mean, on the website, there's all sorts of information on there, but quite often you're not really, okay, you can do this, this and this, which is what you've already done. There's no indication, well, what do you do once you've done all the things? You know, basically wait. So that's what I had the problem with, was the wait time.
What was your experience of using My Aged Care?
I felt that it was basically a call centre. I was ringing a call centre, not necessarily people who knew the needs of people in the aged care bracket that they were. You know, they basically, I got the impression, read from the screen, yes, this is your mother, this is her name, she's on the wait list. So it's 3 to 6 months for level 2 and 12 months plus for anything higher, end of story kind of thing. Which is why I used to say, could I speak to the supervisor please to see if I could get more information. One time I actually got the wrong information from the person who was reading off the screen. They obviously made a mistake, which was about 8 months in. She looked Mum up and she said, oh yeah, she's got a level 2 package. And I went, really? But it turned out she didn't. So I didn't think she did.
You've told the commissioners that your mother had a second ACAT assessment.
Mm-hmm.
What then happened, Mrs. Harris?
So the first ACAT assessment, she was assessed at level 3 medium priority. The second ACAT assessment, which would have been in May the following year, May or June I've got here, when she was really unwell and was hospitalised and then had respite when she came out. She had an ACAT then and it was increased to level 4. So then she had a level 4 priority.
Operator, could I ask you to please display document ID RHA stop 0001 stop 0001 stop 0001. Mrs. Harris, could I ask you to take a look at the monitor in front of you?
Yeah.
And could I ask you to describe the contents of the document before you to the commissioners?
Yeah, that's the letter we got from My Aged Care in November, telling us that, yes, you've moved up in the queue and we'll get a package within, what did it say, the next 58 days or something. I found, we got that letter probably just before then. Mum had a third ACAT assessment, and yes, I found that letter rather patronising in its tone, you know, like we'd been in the queue by then for almost 12 months, well, it would have been 12 months in the November when we got that letter, and it was, you know, just the tone of it, get ready to receive your Australian government home care package.
Why was that? Why did you have that reaction, Mrs. Harris?
Well, I just felt you've been ready to receive your government home care package for the last 12 months since your first ACAT. You know, it just seemed like, here, we're giving you something finally. You know, you should be pleased, you should be happy. But I just think, well, you've already made an elderly person, a person who's over 90 years old, wait 12 months. And I felt quite strongly sometimes when I would speak to the operators on the phone, I'd say, do you realise these people are in their 90s and you're asking them to wait 12 months plus for a package? Now that's a long time when you're already very elderly. I think I said to them, you're waiting for them to die. So, yeah, I did feel quite strongly, and I just felt that, because it wasn't offering you a package, it's saying, oh, wait another 3 months and then we'll send you maybe a level 2 one. So it wasn't anything, it's a nothing letter.
You received that letter just after your mother's had a third ACAT assessment.
Yeah, I think it was the same week actually, because I mentioned it to the ACAT assessor. Look, we've just received this letter. Yeah, so she had a third ACAT assessment, yes.
What do you say you needed from My Aged Care in place of that letter?
The offer of a package would have been good.
Whilst there's this period between the second and the third ACAT assessments, was your mother receiving any care under a package at all?
Only the government interim fund, the Commonwealth interim funding. That's all you can access. If you want anything over and above that, then you need to pay for it privately.
Which is what you did.
We did with food, yes, and with cleaning. But if she needed any other personal care, like we would have liked someone to come in twice a day, to come in the evening time as well, to prepare tea, help with food preparation, but that was just not possible financially.
And why wasn't that possible financially, Mrs. Harris?
Because I think the charge is about $49 an hour if you, you know, get someone the support privately, yeah, from the carers. It's quite expensive.
In mid-December 2018, you tell the commissioners at paragraphs 35 and 36 of your statement that your mother continued to wait,
Yeah.
and that ultimately a decision was made that your mother would move to residential care. On what basis did your mother and did yourself and your brother make that decision?
So when Mum had her third ACAT, she was still level 4, but then she was high priority instead of medium priority, and the ACAT assessors then were quite confident that yes, your mum should receive a package then, but we hadn't received anything formally yet, and a bed became available where Mum had been having her respite, which is also part of the same group that she has her independent living with. And she felt very comfortable there because some of the same people are there that, you know, that she's familiar with. And basically, I think she decided, well, we can't keep waiting forever. Probably, I was a bit concerned that she was doing it for my benefit as well, rather than just for hers, because she felt, you know, we were providing a lot of support for her in terms that, well, just like I did all her washing by then and all of those sorts of extra things, appointments, all of those sorts of things. And she said, so there's a bed there, let's go and have a look at the room, which we did. And she said, yes, right, I'm going to move, because you don't know when another bed will become available in that facility. So you've got to take opportunities when they arise.
And how long had your mother been waiting for a package at that time?
13 months.
After your mother makes that decision, did you have further contact with My Aged Care?
I didn't ring them then until the middle of January. Mum moved in the beginning of January, and we had Christmas in the interim and whatnot. So after Mum had moved in, that following week I thought I better call them and say, well, you can take Mum's name off the list.
And what happened when you called them, Mrs. Harris?
So I rang My Aged Care, told them I was ringing for my mum, and the operator brought Mum up and said to me, oh, are you calling to extend the deadline on your acceptance of your package? And I said, I beg your pardon? I don't know what package you're talking about. She said, oh, your mum's been offered a level 3 package. And I said, not to my knowledge. And she said, oh, it says here that we sent you a letter on December the 11th offering your mum a level 3 package. And I said, well, we never got that letter. So then she said to me, would you like to speak to a supervisor? So I said, yes, please. So I spoke to the supervisor. I said, I've just been told that my mother was offered a level 3 package by letter that was sent on December the 11th. I said, we've never received that letter, and my mum's now gone into permanent care. So.
And what did My Aged Care say to you?
Oh, well, they basically said, well, our records show that she was sent that letter. So, and I said to them, well, it's such an important piece of information for someone that I couldn't believe that the only way that you've chosen to inform us of that is to use basically snail mail. That there wasn't a follow-up phone call, at least, to go with it. I've been registered as someone able to talk on my mum's behalf with them right from the beginning. I said, I think you should have at least given me a call or sent me a letter as well. At least send the information in 2 different ways, not just one letter, which for whatever reason we have never received. So.
Did you take the opportunity to make a complaint at that time?
I did ask then about making another complaint, and was given for the first time addresses of people that I could write to as a complaints commission, which had never happened previously. I'd only been offered the standard complaints, and I said, oh, that's interesting, I haven't had these addresses before. And at that point I basically said, well, Mum's already made the decision to go into care, and I felt that since the Royal Commission had then been set up, that I would write a submission to the Commission, and left it at that. But I did make it clear that I felt when a package is offered, they really should make sure that they sent at least 2 different ways of communicating with the people involved, not just by the postal system.
Can I take you to the present day, Mrs. Harris?
Mm-hmm.
How's your mother now?
She's very well, thank you. Yes, she's a very positive, outgoing person, my mum, whose attitude has always been you make the best of the situation that you're placed in. She's very good at doing that, and yeah, she's very sociable. She's made friends. She still gets to go to church and everything. They have a roster to pick her up, and so I feel that we're very lucky, very blessed that she has had, you know, she made the decision herself, which is a good thing, but my one regret is I don't feel we ever got to try out the level 3 package to see how that would have gone, and maybe she could have stayed a bit longer at home.
Has your mother told you how she feels now about the decision that she made, having found out about the offer of that package after the fact?
Yes, because I said to her, they say you've got a level 3 package, and I mean, we could have said to the home, right, we've changed our mind, because there is a bit of a cooling off period as I understand it, and because it was within the same group, her unit was still there, although the furniture had gone by then. But you know, once she makes a decision, she wasn't going to go back on it or anything, but I think we both said, well, we're never going to know what difference it would have made. So,
and how are you now, Mrs. Harris?
yeah, no, good. I'm very happy. I think the thing that I feel I've wanted to carry on with this, because not just in Mum's case, there are lots of other people who don't have an advocate for them, because how elderly people manage if they don't have family support or someone who's willing to do the paperwork for them, because it's just horrendous. The way that you have to navigate your way through the system is very difficult. So I just felt I wanted to make it known. I'm very pleased to think that now we have the Commission and people's views are being listened to. I did feel when I phoned My Aged Care that no one was listening, basically.
Do you say that there's support that you could have had in order to support your mother during this time?
Sorry?
Do you say that there's support that you could have had to help you support your mother?
Well, I think it would be better if there was more transparency in the whole system about how it works and what's expected of people, because families really don't know what to do until something happens. Because when a person is fit and well and active, you don't need to access these things. Then when something happens and there's a change in their health and you have an urgent need, you want that to be something to happen urgently, because the person who's being assessed needs that support now, you know, not 6 months down the track, not 12 months down the track. So it would be good if well, it all comes down to funding, I realise, but you know, that's really what we need, and a clearer process of how it works.
And do you have an idea as to what that clearer process would look like?
Well, certainly I think it could be more explicit with how it works. I think they send you on tangents here and there, and certainly when informing people, they need to inform people in a wider... I was really quite gobsmacked that they just sent us a letter, when a number of times on the phone I got told, oh, your mum can access this information online. And I just, excuse me, do you realise you're talking about someone who's 90 plus who doesn't have access online? And even for us who do have access online, it's not that easy. I asked once if I could email them, and they didn't seem to have an email address. You have to do everything through the website. So there's obviously a way of doing it through the website. But if you wanted to attach things, because we also had a doctor's letter that said my mum needed more care, you know, but otherwise you would have to fax it to them, or you would have it. It wasn't easy to communicate with them. It's quite a faceless body, I think, you know.
Commissioners, that concludes the questions that I'd seek to take this witness to. I'm minded that I did not tender the correspondence that I referred to.
The Remembrance Day letter.
Yes, Commissioner.
The letter from the Secretary, Department of Health, to Mrs Joyce Edwards, dated the 11th of November 2018, will be Exhibit 2-77.
As the Commission pleases.
Do you have any questions? Ms Harris, thank you very much for your evidence. It's important to us to understand the real-world experiences of people dealing with the My Aged Care system, and you've provided us with some very good example of the sort of experiences that people have had and their carers have had, and we're most grateful to you for that evidence. Thank you for coming.
Thank you.
Yes, Dr McAvoy.
Commissioner, I'd call Mr Graham Barden.
Repeat after me. I solemnly and sincerely declare and affirm
I solemnly and sincerely declare and affirm
that the evidence I shall give
that the evidence I shall give
will be the truth,
will be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Operator, would you please bring up WIT 1066 stop 001 stop 0001. Mr Barden, do you see that there on the screen?
I do.
Is that a witness statement that you have prepared and had filed with the Commission?
I have.
And are its contents true and correct?
Yes.
And you don't wish to make any amendments to it?
No.
Commissioners, I'd tender that witness statement of Mr Graham Barden.
The statement of Graham Barden, dated the 20th of March 2019, will be Exhibit 2/78.
Mr Barden, can you just provide the Commission with an overview of your role in the Department of Health?
So I'm the Assistant Secretary of the Residential and Flexible Care branch within the department, and I have a range of responsibilities there that relate to aged care.
And I think your statement says at paragraph 3 that you've had that role since September 2017. Were you in the Department of Health before September 2017?
Yes.
How long have you been in the Department of Health?
Since March of 2010.
And have you been in aged care parts of the department in that period?
Since September 2017.
But not before?
Not before.
So this statement is dated yesterday. When did you prepare the statement, Mr Barden?
Its preparation commenced on Monday of this week.
And is it a document that you drafted, or did you receive assistance in the drafting? How did that process work?
I received assistance.
Assistance from whom?
So we had lawyers assisting. So I provided material to lawyers who prepared draft versions of the statement, which I reviewed, made changes to, iterated through that a couple of times, and it was clearly put to me that I should not submit nor sign the statement until I was perfectly happy with it from my own perspective.
Now, there's a document attached to your statement called the summary of the approved process for home care provider applicants under the Aged Care Act. You're familiar with that document?
I am.
Operator, that document is CTH 001 1000 4975. Commissioners, I'd seek to tender that document as a separate document.
Yes, the summary of the approval process for home care provider applicants under the Aged Care Act, prepared by the Department of Health, will be Exhibit 279.
Yeah, 4974, Commissioner, is the last four digits of that statement.
I beg your pardon?
4974, I think, are the last four digits of that exhibit, rather.
Yes.
Now, Mr. Barden, are you aware that on Monday the Royal Commission heard evidence from witness BE?
I am.
And is it the position that that witness is employed within the approved provider section?
Yes.
And that's one of the sections for which you're responsible?
Yes.
So your statement deals substantially with the approvals process to become an approved provider under the Aged Care Act. That's the case, isn't it?
Yep.
Would it be correct to say that you're closely involved in that approval process?
So I'm the executive manager of the branch, and so my involvement is to oversight the program, and my specific level of engagement is a weekly meeting with the director who manages the function.
So you say you oversight the program, and you do that principally by having a weekly meeting with the director. Is that the extent of your oversight, or are there other things that you do or are expected to do?
Do you mean in respect to the approved provider function itself?
Yes.
No, no other.
I'm sorry, nothing else?
Nothing else.
Yeah. So would I be right to take from that you don't really have any involvement in the monitoring of the work that people in the section are doing by way of approving providers or not approving providers?
The weekly meeting that I have with the director is an opportunity where the director and I discuss the way in which the applications are moving.
Yeah, I'm not seeking to make any criticism of you in this respect. I'm just trying to understand the extent really to which you're involved in monitoring their work. And I think from what you're saying, it'd probably be fair to say that you don't have that level of hands-on involvement.
That's correct.
So if you turn to paragraph 10 of your statement, Mr. Barden, you make reference to the director, who's the person you're saying you have this meeting with, and you observe that he's the secretary's delegate for the purposes of the decision making that goes on in relation to the approval or the non-approval of providers. Is the director the sole decision maker?
So yes, in practice, yes.
And have you got any idea of how many decisions the director would have to make a day or a week in relation to approved providers?
It would be in the order of 1 to 2 a day.
1 to 2 a day. Now, the witness BE gave evidence to the Commission that there'll be a different person within the department who will make the review decisions, that is to say, review decisions for the purposes of an internal review. Do you know who that person would be?
So the Secretary's instrument of delegation allows these decisions to be made by any officer within aged care at the level of director or above, and those decisions are made by other directors, firstly within my branch.
So other directors who report to you?
Who report to me.
But not ever you?
I haven't done one.
You have not done one?
Have not.
So do you know how long it would typically take a reviewer to make an assessment?
No, I don't have a particular time frame other than the discussions that I have with executive level staff within the section indicate that it could be for a more straightforward application in the order of 1 to 3 days. Some that are more complex that may find their way towards being refused might be more in the order of 5 to 10 days.
Are you aware of how many applications this section has had in the last 12 months?
In the last 12 months...
If that's not...
It's not a number that I have.
If it's not a convenient period for you to answer the question, in the sense that it might be more convenient, for example, to say in the course of 2018 or in the course of 2018, I'd be happy if you gave me that indication.
It's not a number that I can recall right now, but it will be in the order of no, I would be speculating, I'm sorry.
So you've got no idea at all of how many applications there would have been received by that part of the department in approximately the last 12 months?
As I sit here today, I can't give you that number.
Are you aware of whether the number of applications is on the increase?
No.
So you wouldn't know whether it's going up or it's going down?
I know that the number of applications has been reducing.
Number of applications has been reducing, you would say, in recent times?
Yes.
And how recent times would you say that's been happening?
Over the last 6 months.
And reducing significantly, would you say, or are you able to give some sort of indication of what level of reduction we're looking at?
At the moment, I understand we're receiving in the order of around 20 applications per month and have been for the last 6 or so months. And prior, when we were receiving more applications, that would be in the order of around 40 per month.
So it might be approximately correct to say that the number of applications is halving.
Approximately.
How many staff are there in this particular section, if that's the right word, of the department?
I might refer to the team if we're particularly only talking about the approved provider function.
Yes.
So that team, the staff count that I saw as at January was an assessment staff of 10.
And are they all full-time people working in that role, or are they casual people taken on? Are you able to say?
So some are full-time and some are part-time, so that the work and their personal circumstances can be managed by themselves. And some are departmentally employed staff and some are contract staff.
Have you any idea how many are contract staff?
And within that January number, I believe it was 6.
That's a fairly high proportion of contract staff, would you agree?
I don't have a view on whether it's high or not.
How long would you expect, or how long typically do these contract staff stay on contract in the role?
I can't give a specific number, but I do know that it's variable. For some, It might be in the order of 3 months, others would be longer, 6 or more.
So those who are leaving after 3 months, do you have any sense of why they're leaving after such a short period?
There are some who are experienced approved provider assessors under contract, and they will spend time with us, end a contract, turn to personal priorities, and then return to us again.
Are you aware of the 90-day rule that operates here?
I am.
And are you aware of how many applications lapse in effect under having regard to the 90-day rule?
Do you have a particular period of time in mind?
Well,
it's something that I pay attention to, yes.
Yes, I mean, what would be a convenient period of time? Could we talk in terms of the last 12 months, for example?
Yep. So in the last 12 months, the number of applications that exceeded their 90-day period, if I could refer to this financial year instead, we'd be...
So you're talking about the 17-18 year or the 18-19?
18-19.
18-19 year, yeah.
So 18-19 year. My recollection is that the number that exceeded the 90-day time frame is in the order of 10 to 20.
10 to 20. What does that say anything to you about the levels of staffing that you've got in that team?
It is one of the indicators that I use to observe how the assessments are progressing and the relative resourcing, and indicative at the moment is within my statement, if I can refer to that. I included a graph which demonstrated the number of applications both that reached the 90-day period and then those that are determined after the 90-day period, and the relative series on that chart indicate that the number exceeding that has fallen quite dramatically since the previous financial year, and now runs at low numbers.
Is that a roundabout way of answering my question about the level of staffing, such as to say that you think there's adequate staffing, or are you trying to say something else?
I think that there is adequate staffing within that team, yes.
So in paragraphs 11 and 12 of your statement, you talk about training for new staff of this section, and I think you make reference to a standard approach. Is there a developed training plan in place?
The approach to training is that which I've laid out. Can I ask, where you say a plan, what are you seeking?
Well, I'm really asking you about how you approach, or your officers in that department, the director of that team, approaches training. How is training conducted?
Right, thank you. Yes, it's so the standard approach includes that when a new assessor joins the team, they meet with either or both of the supervising team leader and the director of the approved provider section, and in that initial induction meeting, the new assessor is taken through the legislation that applies to the approved provider process, the operational processes that the team employs, is shown a copy of the assessment template, is provided with examples of pre-assessed and predetermined applications, both an application that found its way to approval and one which was refused, and that provides the new staff member with initial materials to enable them to understand how assessments are managed and undertaken. And then the training continues where the assessor is provided with a new and active application and is asked to consider the material that's been provided within the application, to undertake the kinds of research that assessors undertake to check material that is in the application, and to have informed a view of the application, talk with the supervising team leader about that, and that's an opportunity then for the team leader to provide feedback on the way in which the applicant has approached their assessment, provides further guidance if that's required, and then that is augmented by the weekly team meeting, whereby the new assessor and indeed all assessors are invited to discuss the assessments that they have before them, any challenges that they might have, and through that mechanism they can share strategies or tactics to deal with any uncertainties they may have in the application.
So how long would such a person typically be in training?
Well, training is an iterative concept within this function. It doesn't really cease. We seek to sort of reinforce the learning approach, if you like, through the conduct of the weekly meeting.
One of the things you say in paragraph 12 is that there's a guide, the approved provider application pre-assessment and assessment processes guide, and you say at the bottom of that paragraph that the guide is in the process of being updated, and so it's not been provided to the members who most recently joined the team. How long has the guide been in the process of being updated?
For several months. I don't have an exact figure.
Meaning more than 6 months, or?
I don't know for certain, but it could be.
So, insofar as there are new staff members who have joined the team in the course of, say, the last 6 months, although perhaps longer, what are they being given?
So the guide about which we're talking contains and continues to contain useful information about how an assessor practically undertakes an assessment, how to undertake a search of a professional regulatory organisation's website, that kind of thing. So the material that's contained with it is still available to all assessors to use. The updating that's required is to make it perhaps a little more navigable for the assessors, but it is available to all assessors. We just haven't included it in the package of materials that is handed over to an assessor.
So does that mean that they're looking at an older version of it or something, or is that how that works?
So, yeah, there is an older version that continues to be used.
And do you know whether it says anything about what they're supposed to say to would-be providers who are asking for assistance?
I don't know.
In paragraph 13 of your statement, Mr. Barden, you talk about the assessors and their supervisor. That's not you, that's the director that you've mentioned.
No, if I can correct you, it's the team leader.
The team leader, who in turn reports to the director.
Yes.
Yes, I see. So that they have their weekly team meeting, which provides a forum to discuss workflows, possible reallocation of applications at risk of exceeding the 90-day time frame, trends and issues, as well as operational changes. Now, that's not a meeting that you would ever go to or have...
That's correct.
Mm-hmm. So this 90-day time frame, are you aware where that requirement originates?
So it's required by the Aged Care Act.
So insofar as some applications are taking more than the 90-day period, what do you do? What does the team do to deal with those sorts of applications?
In terms of the way in which they assess the application, nothing changes. They continue to assess it to the same practices they would for any other assessment, regardless of where the time frame is situated. At a team level, though, there is consideration of the where applications sit against that 90-day time frame, and if there is a need to move an application from one assessor to another to facilitate the achievement of the 90-day time frame, then we would consider doing that reallocation of the task.
Operator, could you please bring up CTH 1002 stock 1016 stock 1694? So insofar, Mr. Barden, as particular applications are going past the 90-day period, would you accept that might be indicative of a resourcing problem in the team?
It could be indicative of one of a number of matters.
One of a number of problems, or
it may relate to resourcing. It may relate to the complexity of the application.
but if there's a provision in the Act that requires 90 days and you've got more than the occasional application that's taking more than 90 days, would you not accept that that suggests that there might be some resourcing problem?
Yes.
So, one of the things, as I understand it, that can be done in effect to obtain some more time is for the applicant to be asked to provide more information. Are you aware of that aspect of the system?
I'm aware that that's possible.
And are you aware of how many times further information can be requested in order to obtain further extensions?
I don't believe there is a limit.
Are you aware of whether the process of asking further questions is employed by the team to, in effect, extend the 90-day period?
No, I don't believe that's the case.
Well, you are aware is your answer, and you don't think it's the case. Is that what you're saying to me?
Sorry, could you re-put your question?
Are you saying to me that you are aware that that is in fact not a practice that they engage in?
Yes.
So,
sorry, can I be clear that that is my belief? Yes.
So this document that has been brought up, Commissioners, this is Exhibit 242. It's an email chain that has been tendered in the context of another witness whose name has proceeded by way of a pseudonym, BC. She was an applicant who gave evidence to the Commission yesterday. Are you familiar with that evidence?
I heard part of that evidence, but I couldn't say that I'm familiar with it.
So, Here, the original application was made on the 10th of August 2017, and then on the 28th of February 2018, there's a request for further information. So that would be, I think, approximately 171 days after the August application was made. Are you able to say anything about what the likely cause of that delay might have been?
I have no familiarity with this application at all. So no.
Do you know whether it would be usual process to make a request for further information of this kind in an email?
Yes. Where you say in this kind, I haven't read the detail of it, so I can say that request can be made by email.
Yes. Just to be fair, if you'd like to take a moment to review this document, Operator, perhaps if you go to the last page, or perhaps the second last page, so that Mr. Barden can see the 28 February email. In fact, the 28 February email is on page 1696. So if you see there at the bottom of the page, Mr. Barden, that's, and then over the page, that's the request for the further information, if you read through that.
Thank you.
And then going over onto the last page.
Sorry, my screen just changed.
We might just need to take it a bit
sorry.
more slowly.
So I'm
Operator.
checking the email from 28 February 10:33.
That's so, yes.
Yes. Is there a further page you'd like
There
me
is
to
a further
consider?
page, Operator, yes. 1698.
Could I ask that I could see the previous page and this second page? Thank you. Okay. Thank you.
Can I just ask you to note, Mr. Barton, at the top of page 1698, which is the page on the right of the screen, you'll see there's some paragraphs, subparagraph B, C and D. And in paragraph C, one of the questions that's being asked is what policies and procedures you will implement to identify and ensure regulatory compliance with the parts of the Act relevant to the provision of home care. So if I can just get you to bear in mind that that is a question that the approved provider section is putting to this applicant on the 28th of February 2018, 28th of February last year. Now, Operator, could I now ask you to bring up CTH 1002 1001 3863. This is Exhibit 255, Commissioners. Now, what the Commission was told, Mr Barden, by BC was that the application that she made was approved on the 16th of March 2018, so it was approved a couple of weeks after that email that I just took you to. Now, this next document I brought up, do you recognise the nature of this document?
I've not seen this document before.
Have you ever seen a home care assessment contact report prepared by either the former aged care quality agency or by the new agency that's been in effect since the 1st of January this year?
No.
So if you go to, Operator, if you could take the witness to page 3866 of this document. Now, if you see there at about point 3 of the page, under expected outcome 1.2, regulatory compliance, perhaps if you could highlight that, Operator, thank you. You see there, Mr Barden, it says the expected outcome requires that the service provider has systems in place to identify and ensure compliance with funded program guidelines, relevant legislation, regulatory requirements and professional standards. And then if you go down under the heading supporting information, the service provider does not have systems in place to identify and ensure compliance with aged care funded program guidelines, relevant legislation or regulatory requirements. So do you understand, Mr Barden, that what the agency is saying in response to an assessment contact that they made on the 31st of October 2018, and that's on the front of the document that you're looking at, is that as at that date, the service provider doesn't have systems in place to identify and ensure compliance with aged care funded program guidelines, relevant legislation or regulatory requirements.
Yes, I see that.
So this is precisely the issue that's been identified as needing attention by the approved provider section on the 28th of February. You recall that I asked you to note that?
Yes.
Now, if it be the case that this provider was approved on the 16th of March 2018 in a period of roughly 6 months, that is to say up until the assessment contact visit, which is the subject of this assessment contact report on the 31st of October, either there's been a significant shift because in March the team was prepared to accept that this provider should be authorised, and then there's been some sort of a drop-off, or alternatively there's some difference, if you like, between what the Aged Care Quality Agency thinks is appropriate in this respect, and what the team thinks is appropriate in this respect. Do you see what I'm driving at?
I do.
And do you have a view about which of those two it might be?
I have no knowledge of how the approved provider implemented the things that it intended to and that it stated in its application that it would. So I can't comment on that. And otherwise, in terms of the second possibility, I'm not aware of there being any difference in the way in which it was then the quality agency considered these matters compared to my approved provider section.
Do you accept that there may be some difference in the way your approval team looks at this and the way the agency looks at this?
There's a theoretical possibility, but I have not been, it's never been put to me that there is a difference in practice or interpretation between the two groups.
Have you ever asked?
Personally, no.
Do you think you might ask?
Yes, I think I might ask that, yes.
Do you know whether when the team is assessing would-be providers, they tell them that they should join one of the peak provider groups?
I don't know.
Do you know who the peak provider groups are?
Yes.
Do you know whether they ask would-be providers to subscribe to health updates?
I don't know with certainty, but I would not be surprised.
Do you know whether the team asks would-be providers to provide them with draft policies or checklists that indicate that they're compliant with the regulations?
Sorry, I'm not sure I understand that question.
Well, I'm asking you whether you know, in circumstances where assessments are being made by the team, they ask would-be providers to provide draft policies or checklists that would demonstrate that they're able to be compliant with the regulations?
Yes.
You do know, and you think that is what they do. Is that your evidence?
Yes, it is, and I believe that that's in part what the application form calls for.
Operator, could I ask you to bring up...
May I just clarify?
Yeah, sure.
Please. The word draft is my comments don't relate to that word that we ask providers, or applicants I should say, to provide their policies, whether they are draft or otherwise. I can't answer yes or no to that.
Is it just the description of their policies that is sought by members of the team, or do they ask for their policies? Do you know?
I understand they ask for their policies.
Their actual policies?
I think so.
Operator, could you please bring up CTH 1002, stop 1002, stop 0055. I might just ask you to read that first page so you can identify what that document is.
Okay.
You'll see that it's a sanctions decision that was made by the department in relation to BD Proprietary Limited. So, Mr. Barden, this is a sanctions...
Sorry, could I just...
Yes, of course,
read?
I'm sorry.
Thank you. Thank you.
So this is a sanctions notice that was issued to witness BC's business, that is to say BD Proprietary Limited, on the 8th of November 2018. And operator, if you could go to page 59 of that sanction decision. You see there at the bottom of the page, part C, the delegate's findings in relation to an immediate and severe risk. And then if you go over the page to the top of 0060, amongst the extensive and serious unmet outcomes in the home care standards, I highlight the following significant failures to meet the required standards. You do not have a system in place to identify and ensure compliance with aged care funded program guidelines, relevant legislation or regulatory requirements. And the company director and management staff don't have an understanding of the responsibilities of approved providers of home care under the Act. Do you see that?
I do.
So this is a provider who's been approved in March 2018, having satisfied the relevant team that it's appropriate to be approved. And then this same provider is being sanctioned in these terms before the end of the year. To what extent would you say that the delegate of the Secretary who deals with the question of assessment reflects the same considerations that the delegate of the Secretary responsible for sanctioning providers would consider?
The approved provider application delegate has access to materials, evidence through the application form. Research is undertaken by the assessor, and any further information that's been provided by the applicant through the course of the assessment. But I cannot speak to how the Secretary's delegate makes a decision about the sanctioning or otherwise.
Well, I'm not trying to assign blame for this on you, Mr. Barden, but I suppose what I would ask you is whether you think that the system is working appropriately, where a provider is approved in March on the basis of certain articulated, having considered certain articulated matters, and I took you to those, and then half a year later, 6 months later, the department finds that this particular provider is putting clients at an immediate and severe risk.
This is a circumstance that I would not expect.
And which you would say, requires addressing?
Now that I've become aware of it, it is something that I would discuss with my approved provider section, and I would be interested in the details that are behind our assessment.
Do you know whether the approved provider section talks to the sanctions section, as it were?
In my understanding, they do talk to the compliance area, is how I phrase that. Specific details that they engage with, however, I can't. I don't know here.
Do you know whether the approved provider section works with the sanctions section to develop a process of approvals that reflects the expectations that the approved provider section would have of particular providers?
I don't know.
Might I, Council, just ask a question that follows up your evidence just then, Mr. Burton? And that is, do you think it might be that the approval staff that you have take a number of things in faith, in effect, that a newly applying applicant might develop policies, guidance and care plans in that first 6 months, or do you rather not know whether that's the case?
So it's my... the assessors will apply their judgment to the material that's been presented to them in the application, and then what an approved provider does or does not do from the moment of approval subsequent is not a matter that the approved provider section would have any awareness of.
Okay, thank you.
Operator, could you take Mr. Barden back to his statement at paragraph 16? And just bring up 16. I might just get you to read that paragraph and the sub-paragraphs, Mr. Barden.
Yes.
So you talk there about strategies being implemented to manage the forecasted increase, and you list those strategies in A, B and C: improved application forms and guidelines, a streamlined application, engaging additional staff. Just dealing with the improved application forms and introducing a streamlined application form. Not sure whether they're really the same thing or whether they're in fact different things, but in any event, what sort of improvement or streamlining needed to occur? What did these forms look like previously?
So I've never seen the previous forms that were operating prior. But the kind of example that you're referring to is at B, for example, where a provider is approved to provide one type of care, say residential care, and that they were applying then to become an approved provider for home care or flexible care, then a bespoke form was created for them so that they didn't have to provide the department with information that we already had. So it was an attempt to reduce the burden on their application preparation.
And so do you think that these reforms, these changes assisted?
Of themselves, they weren't able to prevent the rise in the work on hand that developed.
Why was the increase in the volume unexpected?
So my understanding is that at the time relevant officers attempted to forecast the effect of the increasing choice reforms, but that and tried to estimate the increasing number of applications that may come, but that forecast was significantly exceeded.
So in paragraph 19, you say in paragraph 19A that additional staff had to be allocated. Do you know how many additional staff?
Oh, different numbers at different points in time. So there were additional staff were first allocated in the final quarter of 2016. Then there were further contract staff levels rose in the subsequent financial year, and further to that, when I became responsible for this function and identified the 90-day timeframe pressures and the work on hand pressures, I moved some capacity from elsewhere within my branch into supporting the existing assessment team.
You may be aware that one of the criticisms of would-be providers that was made by witness BE on Monday, the person from this team, was that it was not uncommon to receive what was referred to as boilerplate applications. Do you recall that evidence?
I do.
And what did you understand the reference to boilerplate applications to be about?
That there may be applications presented to us which, to varying degrees, had the same text included within the application.
And are you aware of the practices of consultants in the sector and the way they assist would-be applicants?
I am aware that there are consultants who help the preparation of applications.
Are you aware of what sorts of fees they charge?
No.
Are you concerned about the role that some of the peak provider groups might be playing in this area?
No.
In paragraph 9 of your statement, you say that the role is to assess the suitability of particular organisations. Suitability is a word which might be thought to be somewhat ambiguous in this context. How is a member of the team really able to tell whether a provider wishing to be approved would be suitable?
So the suitability is defined by the legislation, which all the assessors have awareness of through their training and through the work that they do. And the assessment then is made of the materials that are provided by the applicant, having regard to the relevant standards and principles that are attached to the Aged Care Act. And so they form a view then as to whether, in their judgment, the applicant has sufficiently demonstrated that suitability.
But you'd accept, I take it, on the basis of that evidence, that to a very considerable extent, on the basis of how the system is administered at the moment, the assessors in the team make their assessment of suitability on the basis of not much more than what the would-be provider gives them.
Supplemented by whatever researches they've undertaken in the course of their assessment.
And are you aware of what sort of research they do undertake?
So they will, so for example, where key personnel relate to people who are professionally registered individuals, then the assessors will search the relevant other agency databases to confirm the statements that are made about those key personnel. They might, if they are aware of if there is something in their application about which they think there may be a gap, then they can ask the applicant to fill in that gap or provide a bit more information to help the assessor form their view.
Can I take you, Mr. Barton, to the summary of the approval process for home care provider applicants? It's CTH 0001. Yes, that's the document. I think I have already tendered this, Commissioners. Can I take you to paragraph 4, which you'll see there at the bottom of page 2? Now, that's a list of the matters that the assessors have to have regard to. Do you know whether the assessors are provided with elaboration as to what the factors that are set out in section 8-3 of the Act actually entail?
No, not in detail.
If you could move, operator, please, to page 3, the next page of that document, and to paragraph 9. Now, you say there that in the 2017-18 year, 42% of applications were approved and the balance were either withdrawn or refused, or a relatively insignificant percentage of applications being made by government authorities which are taken to be approved. For a 47% refusal rate, which might in fact more realistically be said to be a 56% refusal rate, because presumably the ones that were withdrawn would be likely to have been refused had they not been withdrawn, is a pretty high rate of refusal. Would you agree?
Yes.
Do you know how many of these sought internal review?
No, I don't.
And I suppose it would follow that you don't know to what extent there were proceedings in the AAT on any of these refusals?
No.
Do you consider that the department should be more proactive in seeking to deter certain applicants in the face of a 47 to 56% effective refusal rate?
We have tried to, it's not so much to deter, our aim is to encourage good applications that can be assessed. So we have taken steps to, where an application has come to us and in our view is deficient in terms of its content, hasn't provided the standard material that should be provided as outlined in the application form, then we return those directly to the applicant and we don't undertake any assessment of them.
I suppose what I'm driving at though is whether deterrence from making application might be approached in a different way to the way that it's presently being approached. For example, whether there might be some sort of initial meeting with the approved providers so that some sort of assessment could be made at an early stage and information conveyed to a would-be provider about their prospects of success. Is that something that would be worth exploring?
Yes, I think it would be.
Operator, if you go to paragraph 5 of the document we're in, it's there at the top of the second page. So if you just read that paragraph, Mr. Barden. So it's dealing with the issue of guidance documents.
Yes.
One of the criticisms that has been made is that there isn't appropriate guidance, and paragraph 5 refers to the document the department has prepared providing guidance, which is attachment C, and then there's also a form for an existing approved provider that wants another care type, attachment D, and then there's also attachment E for government authorities. It looks as though there's at least 3 different types of documents. Are you aware of the terms of these documents?
You mean the content? The way
the content of them, yeah.
Yes. In general, I couldn't go to each point of detail.
All right. In paragraph 10, you note that once a provider is approved, they can commence delivering services and they can remain an approved provider unless their status is revoked. Do you keep records, or does the team, or does the section, or whatever you want to call it, keep records of how many of the providers which have been approved are actively continuing to provide services?
The approved provider section doesn't, no.
Is that something that is done elsewhere in the department?
Yes, the department collects information on the service provision of approved providers. But it's a function that happens in another part of the organisation. I don't have detailed knowledge of that.
Can I just take you then to paragraph 12, which is at the bottom of page 3 of that document, where you observe that the department provides a report of newly approved providers to the Commission each month. Have you ever seen one of those reports?
I feel that I have.
Yeah. Is there dialogue that accompanies the report between presumably the approved provider section and the Commission, as far as you're aware?
The report is actually prepared by another of the sections within my branch, the aged care reporting section, and so it is run and then just provided routinely to the Commission.
Do you know whether the approved provider section, or for that matter any other section, gives anything in the nature of support to newly approved providers, that is to say information about the way the regulations work, what expectations the department has?
The approved provider section does not, and I don't know in respect of other parts of the department.
One of the criticisms that was made by the witness from the approved provider section was that some of the reforms have meant that it's not really possible any longer for there to be a second vetting. And in other words, if a provider slips through the process, that is to say a provider who perhaps oughtn't to have got through the process does manage to get through, then in the end it's up to the Quality Commission to deal with whatever problems come from that. Do you accept that as a criticism?
Yeah, that is a potential.
And you would accept, would you, that that would be another area in which this process might be improved?
Yes, I do.
I think you've observed in your statement that there have been ongoing reforms. Certainly the department has given evidence pretty consistently to the Commission, as is evidently the case, that in this area of government activity there are ongoing reforms. Do you have a view about whether particular functions of your section, including the approved provider part of the department, might be transferred to the Quality and Safety Commission from January of next year?
It's been put to me that the approved provider function could transfer to the Quality and Safety Commission, and I agree with that view.
Who's put that view to you, Mr. Barden, can you say?
Are you after a particular name? Or?
Well, is this a view within the department, or are you referring to the Commission's view? Or
no, it's come up in discussions amongst my senior executive colleagues in aged care.
And so is that to be regarded as being on the cards, that is what will happen with the approved provider section?
My understanding is that is part of the active considerations that are being made.
Commissioners, I don't have any further questions of Mr. Barden.
Thank you. Mr. Barden, I want to explore with you the assessment process as it currently operates. An application comes in and is allocated to an assessor. Is that right?
No, it is first considered. We have an administrative consideration first, so what we call a pre-assessment. So we have an administrative officer who first considers whether the application contains all the material that is required. In effect, is it complete or not? And undertakes certain actions in accordance with that, which may be to return the application or issue a request for information.
And are you able to say roughly what percentage of applications are rejected or returned at that point?
I can't give you a percentage figure, no.
It's a sort of triage operation.
It is.
Yes. All right. And if the judgment is made, well, this is fit for assessment, it's then allocated to an assessor.
Correct.
Is that right?
Correct, yes.
All right. Now, the assessor examines the application and tests it against the criteria that we've been told about. Does the assessor then prepare a report and a recommendation that goes to the delegate?
They do.
Does it go to anybody else before it goes to the delegate?
So it can go to the supervising team leader.
And presumably there is some time discipline which ensures that the final recommendation goes to the delegate in good time for the delegate to make a decision inside the 90 days.
That's what we're after.
If that hasn't happened, and we've heard examples where it hasn't, is the applicant advised that the 90 days hasn't been met and given an explanation?
Yes, my understanding is that a notice is provided to the applicant indicating that the 90 days has been exceeded, and the applicant is advised that the department will continue to assess the application on own motion review.
Yes. And the delegate then makes a decision. If that is an adverse decision, is there a process of internal review?
No, not immediately, no.
So what recourse has the applicant got at that point, if any? Is there a right of appeal, for example, to the Administrative Appeals Tribunal?
Yes, there is.
Now, have you read the transcript of the evidence given by BE to the Commission?
I have.
And you would have seen there that what she told us was that typically an application that comes to an assessor takes about 2 weeks to complete before the assessor passes it up the line. That, she said, applied to the majority of the people in the section, although she said there was one lady who was a bit faster and got through these applications in about 1.5 weeks. Now, I notice you don't gainsay any of that evidence in your statement. Are we to proceed on the basis that that is the fact?
My subsequent inquiries suggest to me that 2 weeks is not a typical period for the average assessor, that it is a shorter period.
Have you taken this up with BE?
No, I haven't spoken to BE.
The other disturbing piece of evidence that she gave us was that typically the assessors at any one time have about 13 cases in their docket, and that that means that the 13th case that's waiting is well past the 90 days. Have you, again, you don't gainsay any of that evidence in your statement. Are we to take it that that is accurate?
My understanding at the moment, and as I indicated in my witness statement, is that we currently have in the order of around 60 applications on hand, and that with the number of staff that we have current, that the number that each assessor would have in their portfolio would be fewer than that.
And is that a matter that you've checked in the course of this week?
No, it's not.
If you were to go back 6 months where there were on average 40 or twice the number, then it would take you, I think, to on average they'd have 12 per person, so that might reconcile those numbers. But that's not what I want to ask you. For the benefit of the Royal Commission, there's a Commonwealth term called average staffing levels, or ASL. And then there's a cap that the government imposes on the level of average staffing level. What's the cap for the approved provider section?
So the cap doesn't operate at the level of a section.
Okay. Do you have a feeling for what that is? And my question is really, is that driving the employment of consultants?
It is, yes, it is easier to employ consultants when you've reached your cap. You can employ consultants.
Thank you.
Anything arising from that, Dr. McAvoy?
Well, just I think in relation to that last question and answer, you say that when you reach the cap, you can employ consultants. But with respect, I think the Commissioner's question to you was really, is that what's driving the appointment of consultants in this team? And are we to take your answer to that question as being yes?
Can I first clarify, if I said consultants, I meant contracted staff? Just, that has a difference for us in public service.
I think you did actually say consultants, yes.
Okay,
but
so
you meant
I meant contract staff, yes. And now, having done that clarification, I would have to ask you if you could repeat your question to me.
Well, really the question is whether this issue of the cap to which Commissioner Briggs adverts is driving the appointment of contractors in the team, rather perhaps than a more organised and permanent workforce in the team.
No, I think for me it's the combination of the two different types of resource, and so
the two different types of
resource.
resource.
Permanent departmental staff or contracted staff. So the way that I look at it is, as providing my witness state, the work on hand is reducing quite significantly. So we've gone past that peak period, so what I continue to do is look at the nature of the staffing profile, the continuing allocation or contracting of staff is consistent with monitoring a downward trend and looking to see where that plateaus. But I have the circumstances aren't that I cannot put on departmental staff, and it was Friday of last week, and to be clear, this is before that I knew that I would be appearing before the Royal Commission. On Friday of last week, authorised actions to bring about the permanent transfer of a departmental officer into the approved provider section to undertake assessments of applications to become an approved provider.
So, sorry, your point is that you decided to do this anyway before you even knew you were coming along here to give evidence about this?
Yes.
I don't think I have any further, Commissioners.
Yes. Thank you very much for your evidence, Dr. Barden. That's been most helpful. The Commission will adjourn until 12:25.
All stand. Royal Commission is now adjourned to 12:25.
Sorry,
Mr.
Commissioner.
Craig.
It was remiss of me not to mention it earlier, but I'd re-announce my appearance with Mr. Arnott for the Commonwealth.
Thank you. Yes, Dr McAvoy.
Commissioners, I'd seek to call Mr Anthony Speed and Dr Lisa Studdart, who are both seated in the witness box.
Thank you.
I solemnly and sincerely declare and affirm
I solemnly and sincerely declare and affirm
that the evidence I shall give
that
that the evidence I shall give
will be the truth,
will be the
will be the
truth,
truth,
the whole truth,
the
the
whole
whole
truth,
truth,
and nothing but the
and
truth.
and nothing but the truth.
Dr Studdart, could you please give the Commission your full name
Lisa Jane Studdart,
and could you indicate your role within the Department of Health?
at the present I'm the Deputy Secretary, Ageing and Aged Care Group.
And how long have you been in that role?
I've been in this role just for a few weeks. Due to some unforeseen circumstances, we've had to do a rearrangement of deputies and the departmental executive.
And what was your role in the department prior to this change?
I was the Deputy Secretary for Population Health, Sport and Aged Care Quality, and that incorporates the area responsible for aged care quality and compliance. And I should add that I acted in the role of Deputy Secretary for Ageing and Aged Care Divisions for 6 months in last year.
And I think you've been in the Department of Health, or in that portfolio at least, since about 2011.
That's correct.
Are you able to provide the Commission with an overview of what you've been doing in the department in that period?
In that period, I spent some time working in a portfolio agency, National Preventative Health Agency. I worked at the Therapeutic Goods Administration for 2 years. I worked in Population Health and Sport Division, and I've spent some time in the Minister's office.
And which ministers were they?
I was Chief of Staff to Minister Susan Lee and a Principal Advisor to Minister Greg Hunt.
Mr Speed, could you give the Commission your full name, please?
Anthony David Speed.
And what role do you hold within the department?
Currently the Acting Assistant Secretary for the Aged Care Compliance Branch.
And you've been in that role for how long?
I've been in that role since November 2018.
And what does that role involve?
So that role is the senior leader for the branch, responsible for administering the National Aged Care Compliance Program.
And I understand you've been in the department for quite a number of years. How long is that?
I've been in the department for 25 years.
And are you able to give an indication of what you've been doing over the last few years?
Certainly. Prior to this role, I was in the role of National Aged Care Domain Manager in the Health Grants Network, and prior to that I was the State Manager in the Tasmanian Office and for a brief period the Victorian State Office.
I think Mr Free and I are both having a bit of trouble hearing you.
Okay.
Both of you, in fact, and so it would be of great assistance if you could speak up a little. Mr Speed, I want to ask you a few questions first about the nature and extent of non-compliance with the relevant standards in home care. So that's the context in which I want to ask you some questions. Can you tell the Commission whether, as far as you're aware, there has been an increase in non-compliance with the home care standards by home care providers in recent years?
There has been a slight increase in non-compliance by home care providers, evidenced by the numbers of sanctions that we've seen over the last 3 years.
Yes, and those sanctions, sanction notices have been increasing in number, have they?
Slightly. The sanctions that delivered in 18-19 are slightly higher than the previous year, by a year.
Do you know how many notices of non-compliance were sent to home care providers in the 18-19 year?
I do not have that figure for 18-19, no.
Do you have it for 17-18?
I believe it was 10.
10, and do you have it for 16-17?
I believe it was 8.
So there's an increase, but not a particularly significant increase.
Not at this stage, no.
Yes. And what sort of non-compliance is being detected in the home care area?
In home care, the unmet outcomes that the Commission is finding and reporting to the Department finds significant numbers in relation to regulatory compliance, governance requirements, planning and assessment and care planning for care recipients. Those are the key common unmet outcomes.
Quality of care, or is that not such a significant cause of sanction?
Quality of care is measured through the unmet outcomes in relation to, for example, care planning.
Does a number of 8 or 10 strike you as a lowish sort of a number?
It is a low number if taken as a single figure.
Well, what do you mean if taken as a single figure?
There are a number of levels below a notice of non-compliance, for example, such as a administrative pathway that may be followed in which a provider is found to have unmet outcomes by the Commission and then returns to compliance, or the Department works with that provider and the provider returns to compliance through a plan for continuous improvement period.
And are you aware of what the numbers are over the 2 periods we're looking at in relation to matters of that kind?
No, I don't have those figures with me.
Do you have any idea?
I'm sorry, I couldn't give you that figure.
Do you know whether those figures are on the increase or the decrease?
I wouldn't want to hesitate a guess.
Could I ask you to make arrangements to provide the Commission with a comprehensive answer to that question by reference, say, to the last 3-year periods?
Yes.
It might be convenient to bring up, operator, the quality of care principles in the home care standards. Commissioners, this is Exhibit 123, and operator, that's CTH 0001 1000 4676. So you're obviously both familiar with these principles. So perhaps if we could go, operator, to part 1, dealing with effective management. Just go a little further. Perhaps if I can direct you, operator, to page 4708. So the standards talk in terms of a continuous improvement approach. Are you familiar with that?
Yes, I am.
And what does that actually mean?
So the standards are measured by the Aged Care Quality and Safety Commission, and when the Aged Care Quality and Safety Commission undertakes a visit with a food provider, they will look at who's providing home care services, they will look at their standards. In relation to 1.5, they will look at what systems and processes that a food provider has in place to ensure continuous improvement practices are occurring. So that might be, for example, through their response to complaints and feedback provided by care recipients.
So, continuous improvement seems to be both a standard as well as an outcome, because it's also part of effective management. Is that right?
The standard is effective management.
Yes.
The outcome is continuous improvement.
And is there a relevant distinction?
I would say one is a mechanism by which you achieve effective management, and the other is, as you said, an outcome.
Does risk management at 1.6, is that a reference to clinical or administrative issues, or both?
Can be a reference to both.
And where you refer to physical resources, or where there is reference to physical resources in item 1.8, what is that to be taken to mean?
That could be, perhaps by way of example, a situation where a service provider is using the equipment that they have available to them to provide care effectively and safely.
Can we go over the page to 2.2? Oh, I might return to that, operator. Insofar as the standards refer to fitness for purpose, can I ask you, Dr. Studdert, whether you know how soon after a home care provider is approved, is there an assessment of that provider's capacity to meet the home care standards?
Well, that's a process that the Commission undertakes, and that will vary according to the circumstances and information they have available to them. The standard is within 3 years of a provider becoming active with clients, but that can vary enormously depending on the sorts of information that becomes available to them, and that's through the complaints mechanism, through referrals from the department if we become aware of a situation, or any other information that they receive that would suggest it would be appropriate to engage with a provider sooner rather than later.
So, does that answer, am I to take that answer to mean that it's not possible to give any clear indication of how long after there's an approval that there will in fact be an assessment, that it's going to depend on lots of different factors?
Yeah, that's correct.
And yeah, I'll come back to it. And how does that compare to the position in relation to residential care services?
Well, my understanding is, and actually Anthony might be able to assist here that there is a step in residential where there's an accreditation process that's done soon as an operator becomes active. And that reflects the risk and complexity of residential care, which is, of course, different proportionately than home care.
So, do you have a view, and perhaps I'll put this to you, Dr. Studdert, first, about whether the home care standards place enough emphasis on the quality of care being provided to the care recipient?
My view is that it does, through the emphasis on the care plan and the attention that's paid to the capacity and operations of the provider in terms of delivering to that care plan. That's a pretty central part of their operation, and that is the crux of what is being provided to the client.
Do you regard the home care standards as being sufficient for their purpose?
I think that they have served us very well, but as you would be aware, we are transitioning to a new set of standards that have been developed in a pretty extensive consultation process based on the evidence base we have, and which will be a more contemporary and appropriate approach to the regulation moving forward.
Can I ask you some questions about the relationship between the department and the Commission in relation to regulation? Obviously the Commission is responsible for monitoring providers of home care. We've traversed that. How does a particular home care provider find its way onto the agenda, as it were, for the Commission on the one hand and the department on the other?
So, as I mentioned in my earlier answer, there's a range of ways that happens, but it's important to remember that the Commission, a large part of the Commission's operations is a complaints system, and that transitioned from the previous Complaints Commissioner, and there are a large number of staff whose daily work is to field complaints from anyone in a care recipient, a representative of the care recipient, another provider that may be giving us information about another provider. There's lots of that happens, or anyone. So that's a very important entry point to the quality and regulatory system in the way we get intelligence. A lot of those complaints are resolved in the early stages of handling, and that's a good outcome in terms of giving the complainant resolution, but others will point to a process that needs to be initiated in terms of the quality regulatory processes, and that would start a process where assessors would go and visit the service provider, and often at that point they are in consultation with the department, further seeking out information that would expand the picture we have of what the risks or issues might be for a particular provider.
Well, that aspect of it, you would agree, I think, is reactive in the sense that there's a complaint made, and so the Commission will respond to that complaint, and I understand that and accept that. But going back to my question about how particular home care providers might come to be on the radar, as it were, I think your answer was to say that there are a range of ways, and complaints is one of them, obviously enough, and you've just...
I use the term complaints in its broadest possible form. It could also be, are you aware of, do you know, I think we should look at, I'm concerned about, and of course that is on top
Who would be saying that?
people that would choose to provide information to Commission
Yes.
about services or situations that they're concerned about.
Yes. So is there any organic process, as it were, within the Commission for...
Well, they do have a program of regular contacts with providers, and that is to ensure that every provider is in contact and visited on a recurring basis.
And does the department discuss that with the Commission? Are there meetings?
Oh, yes, yes.
For that specific purpose?
Well, there's a range of interactions that occur, but yes, I mean, Anthony and his team have regular contact with the Commission on either broad issues of trends, policy implementation, to actual engagements on services of concern.
So it might be that in the context of meetings of that kind, might it that the department would say to the Commission, well, we're concerned about X or we're concerned about Y, you might want to think about looking into that. Is that the sort of thing?
If that is the sort of thing, or the department may undertake to provide a formal referral to the Commission, either for information or requesting a review of that service as a Type 2 or Type 3 referral.
Now, the part of the department that participates in meetings of that kind, that's not the approval section that we were hearing evidence about before the break, is it?
That's correct.
It's not the approval section.
No.
So does the approval section have any input into these regular meetings between the department and the Commission?
Not as a matter of course at this stage, no.
And do you know whether all or some of these regular meetings are minuted?
Not all of them. Some of them a risk list, if you like, is considered.
I'm sorry,
If a risk list of providers is considered.
So what you're saying the department or the Commission or both operate a risk list?
At the one of those meetings, one of the points of interaction with the Commission is a service providers of concern meeting, in which we have a list of providers that may be either under sanction, under a notice of non-compliance, which provides a basis for conversation regarding where those cases may be at.
So you've referred to a service provider of concern meeting. Is that the name of a regular program of meetings, is it?
That's correct.
And that's between officers of the department and officers of the Commission?
It involves representatives from the Commission, but it's primarily a departmental group.
And how often does that sort of meeting occur?
At the moment, fortnightly.
So once a fortnight there's such a meeting. And is that meeting minuted?
No.
How many people would attend that meeting?
It will vary depending on the case that may be considered as a particular concern, but generally it would be around a dozen staff, involving staff from the National Office and from the State Office network of the Department.
So these dozen people who meet as a part of this specific program of meetings once a fortnight, it's not minuted. Do people take informal notes?
They may take informal notes, but as I mentioned, the key the key format for discussion is the register of risk.
Well, what do you regard as a serious risk?
Serious risk is a term that's identified in the Act. Serious risk is a term that's used by the Commission in terms of their findings, and it's a term that relates to where there's a potential adverse impact on the care and safety of a care recipient.
And what's a serious risk report?
The serious risk report is a report that the Commission provides to the department where they become concerned about care and safety of a resident or a care recipient.
So would these serious risk reports be routinely discussed at the service provider of concern meetings?
They can be. Where there's a particular case in relation to a particular provider, there may be a more targeted conversation about that particular case.
So you said that the serious risk reports are provided by the department, provided to the department, by the Commission. Are they provided to the department prior to their finalisation by the Commission?
It will vary depending on the circumstances.
Are you aware of whether there are any current home care providers who have a serious risk finding but haven't been sanctioned or issued with any notice of non-compliance?
No, I'm not aware of that.
Am I to take that answer to mean that you simply don't know, or you think there are none?
I'm not aware of those cases. No.
But that's something that you could relatively easily find out, I would imagine.
That's correct.
I might ask you to endeavour to provide that information to the Commission, perhaps over the last 3 months. Now, what about the proportion of serious risk findings that don't turn themselves into a sanction or into some sort of notice of non-compliance? Are you aware of that?
I'm not quite clear what you're asking me.
So there will be presumably some serious risk findings that don't turn into sanctions or notices of non-compliance. Would I be right in surmising that?
It would be unlikely that a serious risk finding would not turn into a notice of non-compliance or a sanction.
So you think that it would be unlikely? Would you be able to say that it's always the case that a serious risk finding would turn into a sanction or a notice of non-compliance?
There would be variation on a case-by-case basis, but generally I would say that yes.
Just so that we're dealing in the territory of certainty, could I ask you to consider that question, say over the last 6 months, and provide to the Commission the results of that consideration?
Thanks.
So, if the department is going to decide to take regulatory action in relation to a home care provider, can you walk me through the information that it might typically have regard to?
Typically, the department will have regard to, the delegate of will have regard to the information that's provided by the Commission.
And would that be all?
The delegate can consider all reasonable evidence, including history of non-compliance by a particular provider.
Well, that would also be material, wouldn't it? That would be referred to the delegate by the Commission.
That is also that's correct. Yes.
So would there be anything else other than material coming from the Commission? I'm really trying to understand whether, in a functional sense, the department's only source of information is what it hears one way or another from the Commission, or whether there are other sources of information.
The delegate can consider any information that's relevant to a case.
Sure.
Can I just add to that? I think it's important to note that in cases where, particularly where there's serious and immediate risk identified and there's an early referral to the department, the process moves very quickly then to notices of non-compliance and sanction because of the risk that's identified. And So I think the delegate would be not pausing too long to consider other information when that has been the case.
So would it be the position that the department doesn't really conduct any sort of independent assessment of the material that's provided to it by the Commission?
No, because that's the system, is that we rely on and act on the information and advice of the Commission.
Are you aware of whether the department ever disagrees with the views or the assessments of the former agency or the present Commission?
I'm certainly not aware of any case, and I think that would be highly unusual.
That's correct.
But if you've been following the evidence, you'd be aware that it would not be highly unusual for the agency and the department to come to quite a different position in relation to sanctions.
I wouldn't agree to that proposal, no.
You would not agree. You would not agree that might occur.
I can't think of an example.
So the department might issue a notice of decision to impose sanctions where there's an immediate and severe risk to the safety, health or well-being of care recipients. What would you regard as an immediate and severe risk?
Well, the situation where care recipients are not, we are not confident that they are getting care that is appropriate and necessary as a care plan would have indicated. And so in some cases, the absence of a care plan alone would give us great cause for concern, because there is no documentation by which you could verify that a recipient, a client was getting appropriate care.
So you would say that if there isn't a care plan, that might provide an appropriate basis to conclude that there is an immediate and severe risk to the safety, health or well-being of a care recipient. That would be your view, would it?
I think in the absence of anything else to indicate otherwise, yes.
So who makes the decision about whether there's an immediate and severe risk?
That would be made by the delegate of the Secretary in the department.
Operator, could you bring up CTH 1000 stop 1015 stop 0227? So this is a document. This is a document that you have provided to us as a summary of the sanction process. Which of you is more familiar with this document? Which of you has got better vision?
Yes, okay. I think Anthony is, although I am familiar with it also, but Anthony uses it as a daily tool.
I wonder if, Mr. Speed, you might walk us through how this actually works as a practical matter.
So, thank you. I'll use the example of the box on the left, which is the information referred to the department from what in the production of this document was then the Aged Care Quality Agency. The Quality Agency may provide advice to us in relation to unmet outcomes, in this case in your context in relation to home care. So the department will assess that information and whether it is non-compliant under the framework of the Aged Care Act. A delegate may determine whether further information is required, or under the regulatory framework may determine that non-compliance is confirmed, and an initial risk assessment in relation to the service provided to the care recipient will be conducted, followed by a more detailed risk assessment where non-compliance has been confirmed. The delegate may then choose to conduct administrative response or a more detailed analysis based on the determination they've made about the severity of the risk to the care recipient. So, subject to their decision, an administrative response may be conducted through engagement with the approved provider to monitor their return into compliance, or a more detailed risk analysis and the determination around immediate and severe risk may lead them to make a decision about issuing a notice of non-compliance, or indeed a notice of imposition of sanctions. The notice of imposition of sanctions will be determined by their assessment of the immediacy and the severity of the risk. Where a notice of non-compliance has been issued, the notice of non-compliance will be provided to the approved provider, who has an opportunity to respond to that. Their response will be analysed through their submission. Determination of whether their response is satisfactory or not will then determine the decision around issuing either a notice of intention to impose sanction where their response has not been satisfactory, or indeed a notice to remedy or an undertaking to remedy provided by the approved provider where the submission proves to be satisfactory. And indeed, in some cases, a submission may lead to no further action where there's evidence provided that there was no non-compliance currently. So they're the key pathways that that document details.
Commissioners, that may be a convenient time.
Very well. The Commission will adjourn until 2:15.
All stand. All commissioners now adjourned to 2:15. Royal Commission is now in session.
Yes, Ms Hill.
If the Commission pleases, I call Ms Konoski. Ms Konoski appears by video link, Commissioners.
Yes.
Ms Konoski, can you hear me?
Yes, I can.
Okay, so you're going to take the affirmation, so if you could just repeat after me.
Yes.
I solemnly and sincerely
I solemnly and sincerely
declare and affirm that the evidence I shall give
that the evidence I shall give
will be the truth,
will be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you.
Mrs Konoski, can you see and hear us okay?
Pardon?
Can you see and hear us okay?
Yes, yes.
Mrs Konoski, could I ask you to please state your full name?
My full name is Rita Mae Konoski.
What age are you, Mrs Konoski?
I'll be 81 in May.
And you're currently at the courthouse in Gympie in Queensland?
That's true.
How far is Gympie from Brisbane?
It's about 160 kilometres
And does that make
and
Brisbane...
about... Pardon?
You go.
And it's about an hour's drive from the Sunshine Coast
Now,
to the north.
have you prepared a statement dated the 13th of March 2019?
Yes, I have.
And have you got a copy of that statement in front of you?
Yes, I have.
If I could ask you to take that statement that's in front of you and turn it over. And I'll ask the operator.
Okay.
You've got that statement there, Mrs Konoski?
Yes, I have.
Operator, could you please display the document ID WIT 0088 stop 0001 stop 0001? Mrs Konoski, we've now got a copy of your statement in front of us in the hearing room in Adelaide. Are there any
Yes.
changes that you'd seek to make to that statement?
No, not at all.
And to the best of your knowledge and belief, are the contents of your statement true and correct?
Yes, they are.
I tend to that, Commissioners.
The statement of Rita Mae Konoski dated the
13 March.
13th of March 2019 will be Exhibit 2/80.
As the Commission pleases. Mrs Konoski, your son Lester attended the Gympie Courthouse with you today, is that right?
Yes, he has.
And he's just outside the room that you're in at the moment.
Yes,
And
yes.
your son Lester, is he in his 30s?
Pardon, he's
How old's
in
he?
his 50s.
In his 50s.
He's 57.
And do you think he's out the front there watching you on the web stream at the moment?
I'm not real sure.
And you've got two other sons, don't you, Mrs Konoski?
Yes, I do.
And
One
whereabouts?
in Brisbane. One in Brisbane and one in Townsville. And I expect they'll be watching.
How long have you been living in Gympie for, Mrs Konoski?
Since 1980, about 40 years.
And Gympie was where your husband Cole was born and raised, wasn't it?
Yes, that's right.
Could I ask you to please tell the Commissioners a bit about your husband?
My husband, we were married back in 1961 and he was a happy-go-lucky sports-playing person, and in his late 50s his personality changed a lot, and then it was eventually diagnosed, probably in his late 60s, that he had dementia, vascular dementia and aggressive Alzheimer's, and I looked after him. He's been gone now for 4 years, but I looked after him from then until he went into care about 20 months before he died.
And what did that mean in terms of the sort of care that you were providing for your husband?
Well, it meant I had to be very patient and tolerant, because his personality had completely changed and his moods had completely changed. And it was, the doctor virtually advised me to have a sense of humour about things that he did, and not to let them bother me a real lot.
And did you ultimately make the decision to put Cole into residential care?
Yes.
And how did you make that decision, Mrs. Konowski?
He had become very verbally abusive, and one day he was going to bring a bucket of dirt into the lounge room, and I tried to stop him, and he just shook his fist at me, which was completely out of character. He'd never struck me, he'd never done anything like that, and the doctor just said time he was in care. So he was obviously aware that his aggressiveness might get a little bit more physical and that's the reason why he went into care.
You're currently retired?
Yes.
Could I ask you to tell
And have been for about 20 years.
And what did you do for work before you were retired, Mrs. Konowski?
Had various occupations. I worked for about 20 years in bakeries. My dad was a baker, and that seems to be how I first started there when I was about 13. And then I worked in a fabric store for a time, and also had friends who owned a commercial laundry, and I worked there helping them out for a time just before I retired.
When your husband Cole went into residential care, did you stay living at the same house that you and Cole had together?
Yes.
And then did
I did.
Did you ultimately move from that house?
When I moved from the one house here in Gympie to a smaller house just before he went into care, and it's just been good for me. It was a big job to do at the time, but it's been good for me now because I'm in a smaller house and closer to my son.
And your son, in fact, lives next door with his family. Is that right?
Yes.
I want to ask you some questions about My Aged Care. In 2018, you accessed My Aged Care, didn't you?
Yes.
Why did you access My Aged Care?
Because I at the time I asked for an ACAT assessment, and I was told that they would decide whether I needed an ACAT assessment or not. And then I had a fall that's given me a lot of trouble from September last year to now, and even my doctor has asked them to do a reassessment, but they've just done another RAS assessment, which is what ACAT does before they send you on to have an ACAT assessment. So I really haven't got a lot of satisfaction out of my aged care, and I still don't have any help.
Is it correct to say that in September 2018, that's when you had your first ACAT assessment?
Yes.
And what was the outcome of that assessment?
They gave me numbers to say that I could have domestic help, gardening help, and help with maintenance. But I haven't been able to get, I've had to pay someone to do my garden because I can't weed or bend so well anymore. And as far as maintenance is concerned, I've just got to call on Lester to do, or if the other boys are home, I call on them. And I'm supposed to be getting some help in the house, but that was probably a month ago, if not longer, and I still don't have it.
And you told the commissioners that you had a fall, and since you've had that
Yes.
fall, you've had further difficulties.
Yes,
Did you contact My Aged Care after that fall?
yes, yes.
And what happened when you called up?
And they just quoted me numbers. They said, you've been assessed, and quoted me numbers, and like I couldn't even walk to Leicester and over to his place to get a meal because it was just so painful. And, you know, I got really upset on the phone call and just I actually ended the phone call by saying, well, I'll just sit here and starve to death. And I just got no help whatever from My Aged Care.
And you told the commissioners that you spoke to your GP about My Aged Care.
Yes.
What did you talk to your
Yes.
GP about?
Well, I said to him that I needed care. He said, yes, we need to get you some help. And he sent My Aged Care an email asking for me to be reassessed, and they virtually rung me back and said, no, he didn't give enough information. I would have thought if the doctor asked for me to be reassessed, that should be enough. But it just didn't. It didn't happen that way.
And do you say, Mrs. Konoski, that the type of help you need at the moment is in fact different to when you were first assessed in September of last year?
Yes, yes, definitely.
Have you received a further assessment?
The first day that I heard from Jody, on that same day they came to the house, but there was really not an assessment. It was just the lady who came rung a few care providers, and she got on to All Aged Care, which was one of the providers, but I really haven't heard from them since. They said they could provide assistance for me, but I haven't heard from them since.
And when you refer to Jody, you're referring to one of the solicitors who works for the Royal Commission?
Oh, Jody Moore, yes.
And that was about 2 weeks ago, was it?
Oh, probably a little bit longer than that, I think. Maybe 3.
Could I ask you to turn to your statement, Mrs. Konoski, and turn to paragraph 31 of your statement?
Yes.
Now, at that paragraph of your statement, you give evidence that you learnt to use an iPad and an iPhone.
Yes.
Could I ask you to tell the commissioners how that came to be?
It really started off, our youngest son had a phone that he wasn't using, and he offered it to us because this was in the early stages of Cole having been prescribed or diagnosed with dementia, and Cole sort of, we don't want one of those things, but Malcolm insisted that we have it because of travelling with, you know, Cole had given up driving. I was the one that did the driving, and we used to travel to visit our boys, and Malcolm decided that we needed, for safety's sake, more or less, to, when we were in the car. And strangely enough, it was Cole who wanted to use it first. we were driving and the car was acting up a bit. It was only a new car, and he blamed me for not driving properly or something. And I said, it's not me, it's the car. And so we pulled over the side of the road, and he said, have you got that thing Malcolm gave you? And so we used it right there and then.
And did Malcolm help you with how to use the phone?
Oh yes, I sort of thought I'd got to learn a bit about this, so I laid on the bed one day and I texted him, and my first texts were, you know, just a whole lot of words, and he wrote back and said to me, where's your capital letters? And I said, oh, I'll find them, got to find the capital letters. And then he started about my punctuation, and I sort of had to find that. So as that I wasn't getting a bit more, you know, teasing from him. And in the finish, I got quite confident with doing emails and sending messages. And then later on, one of the boys said, oh, you need to join Facebook, Mum. And because everybody was so scattered, the grandkids had grown up a little bit, and he said, you know, you'll be able to keep in touch with everybody. And so, yeah, I learned how to do much more on my iPad. So I feel pretty confident about it now.
Do you enjoy using the iPhone and the iPad?
Yes.
What about it?
Keeps me in touch.
Is your experience with your phone and your iPad something that you've shared with other people as well?
Oh, yes. For some reason, some people think I'm a whiz on my iPad and iPhone, and I got asked at our local Probus meeting to speak about my experience on learning my iPad and iPhone, and so I sort of was a bit bewildered because I'm not the best at public speaking, and I just sort of thought, well, I can only tell it as it is. So I started off with how I started and how the interest kind of got me, you know, all the way through, and I just finished the conversation with virtually saying, if this old lady can do it, so can any of you, because most of the Probus people are retired people my age, and maybe some younger, some older. So it was pretty easy to just speak about, you know, how I'd done it, because it was just how I did it.
Have you ever accessed My Aged Care online?
I've tried. It's almost hopeless. It's some days you'll get a message to say they're not online at the moment, and some days you'll get so far and then you can't get any further, and it's just hopeless. So I hang on the phone for sometimes, you know, an hour waiting for someone to answer.
Do you still use the online service of My Aged Care?
No,
Would you go back to using the online service of My Aged Care?
it'd have to be improved a lot
What would you need it?
to make it. It needs to be improved a lot to allow older people to be able to access it. My Aged Care is there for older people, and a lot of older people don't have there's such a lot of them, they might have an iPhone, but they don't use it for anything but making calls. Or they might have, a really efficient phone, and they only use it for making calls because that's what they need it for. So My Aged Care needs to be, something done about it, making it easier for elderly people to access it.
Do you then prefer to use the telephone when you're contacting My Aged Care?
Yes, I do.
Could you tell the Commissioners about your experience of contacting My Aged Care by the telephone?
Well, usually to contact My Aged Care on the telephone, you put on hold because everybody's busy, nobody can answer you, and you just put on hold, be it for 10 minutes, 20 minutes, an hour, it just depends. And you almost get, sick of waiting. And there again, I can understand a lot of older people not understanding why they have to wait so long. Some get confused to say that they must have disconnected me, It's not just easy.
Have you ever taken this up with My Aged Care when you've been speaking to them?
No.
Are your children eligible for support in their support of you, Mrs. Konoski?
No, unless my children are all boys, and unless they're dressing me and showering me and all that sort of personal stuff, they aren't eligible. As much as the boys do for me, the two that are away, when they're home, they do so much for me, and then Lester does such a lot for me as well. But he's not eligible to be my carer because he doesn't live with me, and he needs to be there so many hours a week to make sure, like, he's got to put me to bed and all this sort of thing, that what he does is a great help, but they don't think that that's worthy of any kind of him being classed as a carer.
What kind of supports do you think there should be for people like your son who's caring for you?
Oh, I just think that he should be, anybody, not just him, but anybody who's, there's lots of families who are doing lots of stuff for their families and probably saving a lot of time and money for other people, that they should be classed as some kind of help and receive some kind of remuneration for it.
You've told the commissioners about your experience of caring for your late husband. In paragraphs 18 to 27 of your statement, you give evidence that Cole was assessed for ACAT when you were in your late 60s.
Yes.
Were you asked at that time whether you would like to be assessed also?
Yes.
And what did you say?
And I thought, I said, oh, no, I'm all right. Because, gee, I was only in my late 60s. And I've always led a fairly active life and been able to do everything I wanted.
How do you feel about that decision now, Mrs. Konoski?
No, it's probably a little bit of regret there, because back then, if I'd have had some kind of an assessment at the time, I'd have been, you know, on the list. I'd have had an early step in there to. It's just become harder now, because back when Cole had his assessment, the doctor just gave me the number to ACAT, and I rang them, made an appointment, and they came when they could. Sure, we probably had to wait a little while, but they came, and he was assessed straight away, you know. And now, because you've got to go through my aged care, it seems to me as if there's a lot of personal opinions come into whether you should be assessed or not. I've always had people say to me, you're much younger than your years, and have always been fairly fit for my age. And, you know, I think when they come into my house and sort of see me, I can walk around okay, but I can't bend to pick anything up. I have difficulty hanging washing on the line. If I sneeze, my back goes into a spasm. And, you know, it's okay if I'm standing on my 2 feet, but I shouldn't be assessed on that. I should be more assessed on what the doctor has proved is severe aggravation of degeneration in my spine.
When you were caring for your husband to live at home with his dementia, were there supports in place that allowed you to continue to care for Cole whilst he was at home?
I probably chose, we had all the care that I felt that we needed at the time. It just became more difficult later on, not, you know, in the couple of years before he went into care. He was still able to dress himself and shower and things like that. It was just his general mood and anger that was sometimes a bit hard to tolerate.
If I could ask you to turn to paragraph 45 of your statement, Mrs. Konoski. At paragraph 45, you tell the commissioners that your husband was allowed to receive about 62 days a year of respite.
Yes.
Was that something that was important to you as a carer of your husband?
Yes, it was.
And why was that?
It was a time where he was being cared for. The doctor had said to me the reason why he wanted him to be in respite, that someone else would be looking after him, but the doctor was more concerned in how I was travelling, and he said when Col goes into respite, not to be there every day, just to visit, you know, when I needed to, and so I used to probably only go maybe 2 or 3 times a week, and the rest of the time, mostly I'd try and get away to the boys, so that I was sort of getting a real break away and didn't have to be sitting thinking about when Col came home again.
Mrs. Kanoski, if I can return to your current situation, how long do you estimate that you've been waiting to receive a package now?
Well, since I had Paul back in September.
Have you been given any advice as to when you can expect to receive a package?
Not really. Well, no, I have to have an ACAT. It becomes compulsory for people to have an ACAT assessment. They've got in place at the moment, like from when I was 75, and a lady came to the house to just make sure that things were going along nicely, but that was only once a year, and sure, that's great, but I think there should be more done in that there should be a greater assessment done of any elderly person when they get to a particular age, be it 75, be it 80. I don't think you should leave it much after that, because I think that's when you start going downhill.
And do you think your experience is different, Ms. Kanoski, because you live in a regional area?
Yes. Gympie seems to be an area that misses out on lots of stuff. You know, we're so close to the Sunshine Coast, but we're not the Sunshine Coast.
Michael Booth to the courtroom, please. Michael Booth to the courtroom, please.
Sorry. And yet then they talk about the Rockhampton, Bundaberg area, even Maryborough. There's more things. I had to go away from Gympie to have cataracts removed from my eyes because it couldn't be done here in Gympie. So it's Gympie just seems to be a little area that gets missed out. Even with storms, we've been missing out on storms lately.
Is it important to you, Mrs. Kanoski, to be able to stay at your own home, to be able to stay at Gympie?
Yes, very important. Have lots of friends there, and it's pretty much, you know, central to, I can get to, well, I haven't tried since my back's been acting up, but I can get to Townsville. My husband was in the railway for 39 years and I have free travel on the railway in Queensland, and that's where once it used to take, 21 hours to get to Townsville. Now they do it in about 14 and a half. So, and that's mostly overnight, so it's not a hard job for me to get to Townsville, and I can still drive to Brisbane.
What kind of support do you need, Mrs. Kanowski, to be able to stay at home, to be able to stay at Gympie?
At the moment, I need that help, just general help around domestic help, someone to do a bit of gardening, and maintenance would be another thing. But at the moment, Lester's able to do a fair bit of maintenance for me.
So you've been keeping him busy?
Yes.
Have you spoken to Lester about his experience supporting you?
He doesn't mind. He's pretty easygoing, and if he can't do it right now, he'll eventually do it. And if he forgets to do it, I remind him, so he can't get out of it.
Mrs. Kanowski, what do you ask the Royal Commission to take away from both your and your husband's experience?
Jamie Butler to the courtroom, please. Jamie Butler to the courtroom, please.
Just the realisation, I'm not the worst off. There are lots of people worse than me, but there seems to be an awareness that there's such a lot of people who are struggling to stay in their own homes. It's really difficult to be expecting neighbours and friends. If you're an independent person, it's really hard to accept help from other people who are just friends and relatives, where there could be a better setup that helps people with more help in the home. Friends and relatives can only do so much, whereas there's got to be a better setup that helps people with all their jobs to be able to stay in their homes, and it's a much nicer atmosphere to be in your own home. It must be very devastating I know it was to Cole, to have to go into care. He didn't understand why he was there. He didn't understand his disease, and there's got to be a lot of other people just like him who need the help to stay in their own homes.
Mrs. Kanowski, that concludes the questions that I have for you. Commissioners?
You wish to stay in your own home, and you wish to obtain assistance to do that. As I understand your evidence, you've applied for an assessment that, if it is as you expect the outcome to be, render you eligible for some form of package that will furnish you with that assistance. Is that right?
Yes.
And you've made application for the assessment, but you haven't been assessed. Is that right?
That's right.
And,
I haven't been assessed as an ACAT assessment. I've had a RAS assessment,
and
and I'm not real sure.
has anyone explained to you, in writing or otherwise, why you are not being assessed in the way that is necessary to in order allow you to access the assistance?
No.
When
No,
was
not
the
at all.
last time you had contact with My Aged Care?
Probably about a month ago. Oh no, probably a little bit longer than that I had contact directly with My Aged Care when they phoned me to say that the doctor hadn't given them enough information by just asking for a reassessment.
And did they say to you that they were going to contact your doctor to explain to him what additional information they needed?
No, because I rang my doctor the next day. I spoke to his nurse and I said that I had been refused an ACAT assessment and the nurse was going to pass it on to the doctor.
Yes, thank you. Ms Konofsky, we're enormously grateful to you for taking the trouble to leave your home and come into the courthouse and participate in this hearing at long distance. It's very important for us to understand the way the system works in practice in the community, and in your case in particularly a rural community. And we're most grateful for the insights that you've provided us with. Thank you very much.
That's not been a bother. Just, I've been helped so much by all the girls involved and they've made me feel very comfortable. Thank you.
Well, let's hope we can do something for you. The
you.
Commission will adjourn temporarily.
All said. Royal Commissioners adjourned. Stand. Take a seat.
Commissioner, just before lunch, Mr. Speed had walked the Commission through the document which has just appeared on the screen, CTH 101015-0227. That document is called the National Aged Care Compliance Program Decision Making Procedure. I'll tender that document.
Yes, the National Aged Care Compliance Program Decision Making Procedure will be Exhibit 2/81.
Operator, could you please bring up CTH 1000-1019-3267? Now, Mr. Speed, this is a document that you've provided the Commission. You're familiar with that document?
Yes, I am.
I think in the interests of time, I won't ask you to walk us through it. We'll navigate that for ourselves, but Commissioner, I'd seek to tender that document also.
Yes, the National Aged Care Compliance Program Procedure for Imposition of Sanctions, Immediate and Severe Risk, will be Exhibit 2/82.
So I think, Mr. Speed, before you gave us the benefit of the description of the decision-making procedure chart, we were talking about what constituted an immediate and severe risk. This may have been a question I put to you, Dr. Studdert, and who made that decision. Of course, the department can take other actions as well. How does the department distinguish between a provider being given time to improve on the one hand, as against taking immediate regulatory action?
Well, that goes to primarily the determination that's made around the risk to clients and their daily needs, as would be expected to be provided by that provider. There, as you know, there are a range of outcomes that are expected, and some of those go to business processes and administration of the home care package and the services that we would suggest or we would expect are necessary to deliver that in an efficient way with appropriate transparency to the client and to the Commonwealth for that matter, and others around rights and responsibilities of both the provider and the client. But in the centre of all of that is the service delivery to the client, which goes to, in many cases, clinical care, and assurance that the client is safe and well cared for in their home. And where that is not something that the department can be confident of, then we would determine there is quite likely an immediate and severe risk.
Yes,
Dr. Studdert, can you explain this to me? We have heard lots of evidence of people who have been assessed and found in need of a certain level of care, and for 12 months they don't get anything. Then they get a lower level of care. We've heard from carers who say, we need to give these people a lot more care than we are accredited to give them. We want to spend more time with them, but they're on level 2. They've been assessed at level 4. They're not getting level 4. We can't give them the care that they require. Now, on your analysis, the person concerned is not getting adequate care. How can that be visited on the provider?
Well, I guess at the point where the client has been assigned a package, the system is now into place to assure that they are getting care based on an expert
Not adequate
assessment.
care, not what they're assessed to receive.
And there are other additional services through the Commonwealth Home Support Program that there are processes in place to also deliver to the client.
But not by the same care provider. We're talking about assessment of care provided by an individual provider. And they're not giving the care to the people that they're supposed to be caring for to an adequate level through no fault of theirs.
I would have to accept that premise, yes.
That's the real world, isn't it?
It is.
Dr. Stoddart, you've heard, I assume, the evidence of Ms. Rita Kirsnavoska, who has just given evidence to the
Yes.
Commission. Were you aware of her particular situation?
No, I wasn't until today.
And I don't imagine that in the last 15 minutes you've caused to have anything done about that.
No, but I have indicated to my staff that I would like to do that.
Yes, I was going to ask you whether you had an intention to do that. Well, just going back to my earlier question, my earlier question, which was how you distinguished between a provider being given time to improve versus taking regulatory action in the nature of sanctions. And I think the essence of your answer was really that you would look carefully at whether the recipient was actually at risk, and if that was the position, then that would tend to suggest that you'd move to sanctions.
Correct.
Yes. Okay.
Because if I can just explain,
Yes, of
sanctions give us two mechanisms. They give us the ability to work with the provider, well, to ask the provider to engage an advisor that will assist them in delivering that care, which has been found to be lacking or we're not assured of. And secondly, it enables us to determine that the provider should not take on any more clients until we are assured that they're in a position to provide appropriate care.
Well, just on the subject then of advisors and administrators, as you say, you are able to require the appointment of advisors or administrators. What's the difference between an advisor on the one hand and an administrator on the other?
Well, it goes to the management of the business and then the clinical care and quality of care in the home that is expected. Now, sometimes that can be one and the same person. In other cases, it would be two people, and that would depend on the business offering from the advisor.
So which is which?
Sorry, if I could just say, we don't require it. It's asked of the provider if they want to avoid the revocation of their provider status and work towards improving.
So would it be right to say that an advisor is in the nature of a clinical advisor and an administrator is in the nature of a regulatory business
Correct, yes.
compliance administrator?
Yes.
Now, who pays for the advisor or the administrator if that's a regulatory road?
The provider.
Yes.
It's a business relationship between the provider and the...
And is there any regulation on advisors or administrators?
There is not.
Is that an area for consideration, would you say?
I think that it could be argued that it is. I think that it would be something that we would be inclined to take a broad range of opinions on from a range of providers and business administrators and advocates. There has been more oversight of that in the past, but the advice and feedback at the time was that the providers wanted more flexibility in how they engage with that sort of business service, and that has been so that's where we sit today.
So my question was whether there's any regulation of advisors and whether that was an area for consideration. And I think what you said was it could be argued that would be an area for consideration. What is it that makes you say that could be argued?
Well, I think that the Commission's heard examples of a wide-ranging set of circumstances that providers find themselves in when they're engaging with advisors, and that it's a marketplace that they enter into. I would suggest often with advice from some of the peak organisations that have a broader view of the business and the marketplace in that space. And you would expect and hope that the market would work in that way, and that reputation would lead providers to good advisors, and not to others. And that's the way we've sort of assumed that it would operate. But I guess in any case where that proves to be not the case, there may be cause to look at it again.
So who chooses the advisor or the administrator?
The provider makes that.
With the suggestion from the department?
I couldn't speak to that. I don't know.
I can speak to that. No, the department doesn't engage on suggestions. The requirements for appointment of an advisor under the Act are specified in terms of the provider can't appoint someone who's a disqualified individual under the Act. There must not be no conflict of interest with that individual, and they are the requirements that are specified in the Act.
I think it's something the department would be very cautious and averse to doing, because it is a business relationship between the provider and that service.
So who does the advisor or the administrator owe the duty to?
The provider.
Have you seen, Dr. Stoddart, the evidence of BC that was given yesterday morning?
Yes, I have.
Operator, can I ask you to bring up CTH 1002, stop 1008, stop 0729? Now, I think this is about 3 or 4 pages. Perhaps if we can go to the end. Is it 3 pages? So you'll have to bear with us, Dr. Stoddart. This is an exchange of emails between BC and her administrator. You might recall this from the evidence of BC. The administrator's there, you'll see at about 0.5 of the page on the left of the screen. So there's an exchange of emails between them in relation to an aspect of the administration. Mm-hmm. And operator, if you go back to the first page of the final email in the chain, so what has happened is that the exchange between the provider and the administrator, which was in relation to criminal checks, I think, that's simply been forwarded for the information of an officer of the department. Does that sound to you to be consistent with the administrator owing a duty to the provider?
Explain the duties.
So, my understanding, having talked to the delegate involved in this process in the department, is that this was a period of quite intense communication, three-way communication between BC, the advisor and the department, and there were a range of conversations, meetings and emails in this period. So the circumstances under which that was forwarded, I couldn't comment on. It may have been done after a conversation involving all of them. It may, I don't think it's appropriate to say, assume how that has come about and whether that indicates any questioning of that relationship.
Well, my earlier question to you was to whom does the advisor or the administrator owe the duty? And you said to the provider. And what we see here in this email is effectively unilaterally the administrator is providing details of communications between himself and the provider to the department. Would you accept that?
Well, I wouldn't accept unilaterally, because I don't think that would necessarily, I mean, they could have had a conversation that day that agreed that that was going to be forwarded to the department. I don't know the specifics of that set of interactions. Obviously the department was quite concerned, as you would expect, to assure that staff had criminal history checks, which would have been an expectation from the outset. So there was obviously some intense effort underway to remedy that situation.
Do you recall Dr. Studdert at BC giving evidence yesterday that she did not authorise this email chain to be forwarded to the department?
So I wasn't in the room. I didn't see the documents as they were being reviewed in that proceeding. I do recall that exchange as I heard it. So I wasn't aware that was conversation.
So her position is that she didn't authorise that email chain to be sent. In those circumstances, would you regard that as appropriate?
I would have to. I guess it was not, but I think there were a lot of circumstances in that case that were concerning, and there was obviously an intense effort to get this provider back to compliance.
So when you say there are a lot of circumstances in that case that were concerning, you mean on the part of the provider? Is that what you're saying? When you say the large
number of unmets that we were dealing with,
yes.
We, as a joined-up process, with a large number of clients, relatively speaking, meant that there was a lot of effort underway to remedy that situation as quickly as possible.
That was a pretty serious situation.
By our reckoning, absolutely yes.
Operator, could you bring up CTH 1002-1007-2482? This, Commissioners, is Exhibit 248. Now, you presumably are not familiar with this document, Dr. Studdert.
No.
Perhaps I might ask you to just read that first page. So the position, according to BC, is that she was not copied into this confidential update that her administrator provided to the department. Does that strike you as appropriate or inappropriate?
Look, I think I can accept on the face of it, it is inappropriate, but I would return to the comments I made earlier that this was a fairly extraordinary situation. You know, as is identified there, there were several weeks into this process and they still were struggling to determine who all the clients were and what their care needs were. I guess judgments were made about the necessary steps that needed to be taken to continue to try to address this situation.
When you say it was extraordinary, I take you to be saying, by the use of that word, that it was the department's view that this was at the extreme end.
Yes.
Are you aware of the fees that administrators and advisors charge?
I wasn't aware until I read BC's statement, which did contain numbers.
And would it be the position that their fees are not regulated or monitored in any way by the department?
That's correct.
Do you know for how long a provider typically needs to engage an administrator or an advisor?
The expectation is that they're engaged until the sanction is lifted.
And what if the...
Alternatively, the provider exits the system.
What if the provider is not in a position to pay the fees charged by an administrator or an advisor?
Well, again, that's a fairly extraordinary situation, and as I'm only aware of one case where that has happened under extenuating circumstances.
And what happened in that case?
In that case, the department did step in to pay the fees.
Do you know how much the department paid?
I think someone mentioned a few $1,000s.
It's about $5,600 or thereabouts.
Operator, could you bring up CTH 1000-0002-5317? Are you familiar with this document?
Yes.
Operator, could you go through to page 4 of this document, which is 5320? Dr. Stoddart, can I address your attention to the compliance heading, and in particular the second dot point. In 2018, the department trialled a pilot risk profiling and information analysis approach to inform the regulation of home care providers. Can you explain that pilot risk profiling and information analysis?
So what the department has been working on is more intelligent use of data and available information to enable us and the Commission to more readily and efficiently identify risk where it exists in the home care provision space. With 800 plus providers now, and that number expected to continue to grow. As in any regulated system, you look for more efficient and effective ways to monitor and enforce the regulatory framework. So, as you would be aware, this is a relatively new part of, in terms of consumer-directed care and home care packages of the aged care system, and so we are continuing to work with good evidence and wise counsel on how we can better regulate going forward.
But what does what's the nature of the pilot risk profiling and information analysis approach that was being trialled?
Can I
Yes, of course, yeah.
I can talk to that. In addition to the measures outlined by Dr. Studdart, there was a small pilot project that was run out of the Aged Care Compliance Branch where we voluntarily engaged with a very small sample of home care providers, and we sought to identify through that engagement the issues that they experienced in managing compliance with the home care standards.
So what you met with, or consultants met with a group of providers to talk to them about things?
There was primarily a desk-based exercise with engagement with providers on a one-to-one basis.
I'm sorry, what does desk-based mean in this context?
Assessment of information by officers of the department.
Without actually speaking to a provider?
In addition to speaking to providers on a one-to-one basis.
So the department does have concerns, does it, that new entrants, new providers are not properly equipped to comply with the standards?
I don't think it's a concern in terms of there's anything particularly acute at the moment, but I just, as in any regulated system, there will be problems. There will be providers that aren't either initially capable or fall over or have troubles along the way. As I said, there's 870 plus now, and that's growing all the time, as it should, because we do need to grow the supply for the growth in this system over the future years, and I think it's just inevitable there will be problems, hopefully contained into a small number and readily and quickly detected.
We might go then, Dr. Studdart, to what you've referred to as the extraordinary case of BC, the evidence of whom we heard yesterday. Now, you've provided us with a chronology of events in relation to each of the providers, the subject of NTP 0016. I won't have that chronology brought up, Commissioners, because I think there are still some redactions being made to it, but I would tender the document. It's CTH 1000-0002-6095, and it's the Department's chronology of events for each provider, the subject of NTP 0016.
Yes, the chronology of relevant events relating to B, C and BD Proprietary Limited will be Exhibit 2/83.
Now, underlying facts here, Dr. Studdert, are set out, you'd be aware, in the chronology, and I think you'd also be familiar with them because we were informed of them yesterday by the person in question, and documents were tendered. But in broad terms, you might recall that on about the 31st of October last year, the former regulator, the Australian Aged Care Quality Agency, the agency I'll call it, did an assessment conduct on BC's business. You accept that?
Yes.
Now, about a week later, on the 7th of November, by email, the agency provided an assessment contact report to the department, reporting that the company didn't meet about 9 assessed outcomes of the home care standards. Now, that report was provided under cover of an email, which is, and I'll get you to bring this up, operator, it's CTH 1002 1001 3860. This email, Commissioners, was not tendered yesterday, but I would seek to tender it now, if that's convenient.
Yes, the email exchange between BD Proprietary Limited and the Quality Agency dated the 7th of November 2018 will be Exhibit 2/84.
I'm sorry, Commissioner, it's the email's between the Quality Agency and the Health Department.
Well, why is it headed BD? Oh, it concerns BD.
Yes,
Yes, I see.
in relation to BD. That's
right. Well, who are the parties to this? The Quality Agency and?
The Quality Agency and the Department.
Very well. Well, I'll recast the description of the exhibit in those terms.
Thank you, Commissioner. Now, Dr. Studdert, can I ask you to look at the date of the email? You'll see it's Wednesday the 7th of November at 3:34. Do you see that?
Yes, sorry.
So what the email is saying is that we conducted an assessment and an early release of the assessment contact report is attached. Now, operator, could you please bring up a document CTH 1002 stop 1001 stop 3863. Commissioners, this has been tendered. Are you familiar with this document, Dr.
Yes.
Studdert? Yes. So this is the document that you, or perhaps one of the documents, is it that you had in mind when you referred to the extraordinary nature
Yes.
of this provider?
Yes.
Now, you're aware that the relevant standards with which there was not compliance were 1.2, 1.3, 1.5, 1.8, 2.1, 2.2, 2.3, 2.4 and 2.5?
Yes.
Now, they might fairly be described as governance issues. Would you agree with that?
Yes, correct.
Now,
Sorry,
the
I've
next,
just, that 2.2 and 2.3 do relate to care.
yes, do you want to just tell me what you mean by that?
The three groupings, as you mentioned, 1.1s relate to the administration management of the business. The 2s are generally around care outcomes, and 3s are the rights and responsibilities.
And what were the particular care outcomes in issue here?
I'd have to go to the report where they would be itemised, 2.1, 2.2, 2.3.
Yep, I'm content for you to do that.
Okay. Next forward. But they will have them separately described and so 2.1, service access, not met.
And what's the care issue that is the subject of that difficulty?
Well, it relates to systems that document and support the premise that the care that is necessary for the clients is being delivered.
So it's a systems issue on its
Well,
terms.
in the absence of that, one could not be assured that the care is being delivered.
Are you aware of whether there was any contact with particular care recipients in this case?
I would go to page 3 of that report where it documents that there were 5 care recipients with whom contact was made.
And concerns expressed about the nature of the care being received?
Well, I mean, I'm taking the report as it presents,
yes.
and I would assume that the data that were collected through the assessment contact, through those interviews and document sampling, are what led the assessor to determine that outcome was not met. Which particular bit of data I'm not familiar with.
Okay. Operator, could you bring up CTH 1002 stop 1007 stop 1974? Are you familiar with this email, Dr. Studdert?
I am.
I believe, Commissioner, that this was not tendered, so I would seek.
I think that's right.
I would seek to tender that document.
Well, there appear to be a series of emails in the chain, not a single one. Is that right?
I think two, Commissioner.
Well, I've only got one page in front of me, but even on that page there seem to be 2, and there seem to be one at the bottom of the page.
Perhaps there are 3. I'm sorry, Commissioner.
Anyway, these are exchanges between whom? An officer of the department and an officer of the compliance organisation?
That's so, Commissioner, yes.
Yes, all right. Well, the email exchange dated 7 November 2018 between an officer of the department and an officer of the compliance organisation will be Exhibit 2-85.
Thank you, Commissioner. My learned friend Mr. Free points out that the redaction, there's perhaps still some redactions that could be made. It may be necessary in those circumstances to issue a non-publication direction in relation to that email until that is done.
Well, I don't think it's appropriate to redact the whole email.
That was the view, I should say, Commissioners, that we took, insofar as there were names in there of senior departmental officers.
Well, insofar as individual names appear in those emails, there will be a non-publication order. documents will in due course be subject to redaction to remove those names.
Thank you, Commissioner. Operator, could you bring that document back up again? So you'll see there at the bottom of the page, Dr. Studdert, on the 7th of November at 4:30. So in other words, that's less than an hour after the earlier email I took you to has been received. An officer of the department indicates to, I think, a more senior officer of the department that they've just had an early release of the report in relation to BD Proprietary Limited. 9 outcomes assessed in standards 1 and 2 or non-compliant, likely sanctioning. So within less than an hour, there's a view been taken that there's likely to be a sanction that's been sent up. And then in the top email, that's an indication that a heads up is being given. That's the first line. And then as you go down to paragraph 4, the Quality Agency has since also visited BD Proprietary Limited and conducted an assessment contact assessing 9 outcomes of the 18 and found them non-compliant with all 9. And then it says there in the next paragraph, intend to issue a sanction tomorrow. It might reasonably be inferred, might it not, that there's been in the space of that hour or so a decision to impose the sanction without reading the report. Would that be fair?
Well, I couldn't suggest, and Anthony may be able to add to it, but I think 9 out of 9 unmets, as I said earlier, is a fairly extraordinary situation, particularly when a good number of those relate to clinical care. So I think that headline alone would readily lead the department to be very concerned about the situation.
So, Operator, if you could bring up Exhibit 245, which is CTH 4000-1003-2096. I'm sorry, Operator, I've given you the wrong number. If you could bring up CTH 1002-1002-0055. So this, Dr. Studdert, would I be right to say you're familiar with this document? So this is the sanctions decision. It's dated the 8th of November. In which the department notifies the provider that sanctions are imposed. So this is one of those straight to sanctions decisions on the basis of an immediate and severe risk to the health, to the safety, health and well-being of care recipients.
Yes, that's correct.
And if you go, Operator, to page 0056, the sanctions are there set out. 1, restrict payment. 2, revoke approval. Over the page 3, revoke approval, appointed administrator. 4, revoke approval as an approved provider training. If you then go over to part B, which is at 0059, part C rather, in the second half of the page, immediate and severe risk.
Yes.
There's an immediate and severe risk to the safety, health or wellbeing of care recipients. Satisfied that there's an immediate and severe risk. And then go down to the last paragraph. Extensive failures against the home care standards are interrelated. Failure to meet individual outcomes. Apparent complete lack of understanding of your responsibilities as an approved provider under the Act seriously undermines your ability to properly provide for care recipients' health, safety and wellbeing. Consequently, care recipients are placed at immediate and severe risk.
Yes.
And then you go over the page, the next page, 0060, and you see there those dot points. Let's just go through all of those dot points. You don't have a system in place to ensure compliance with aged care funded program guidelines, so there's some problem there with ensuring compliance with the guidelines. You don't have an understanding of, second dot point, you don't have an understanding of the responsibilities of approved providers of home care under the Act. Third dot point, you can't demonstrate that each service user participates in assessment appropriate to the complexity of their needs. So it's not being said that you don't do it, you just can't demonstrate that you don't do it. You're not able to demonstrate that each service user and their representative has a care service plan. Not able to demonstrate that each service user's needs are monitored and regularly reassessed. Not able to demonstrate that you refer service users to other providers as appropriate. 5 care recipients interviewed are not aware of the services they should be receiving. Now, there's nothing in there that in terms deals with problems with clinical care, is there?
Well, not directly, but as I said earlier, I think our view is that the care plan and the assessment of care needs is a necessary document and process that would lead the assessor to determine appropriate care, to assure themselves that appropriate care was being provided. And short of going to each care recipient on an ongoing and regular basis, that is the documentation we expect providers to have available to provide that assurance and to indicate that they're running an orderly system by which they can manage a range of individuals in a range of settings with presumably a range of different care needs.
But this is these concerns, to use your language, are concerns about whether an orderly system is being run, aren't they?
A well-documented, evidence-based system, yes.
And because there isn't a well-documented, evidence-based system, you embrace the finding at the bottom of page 0059 that care recipients are placed at immediate and severe risk. Is that the position?
Well, I would yes, because in the absence of anything to suggest otherwise, we would err on the side of caution to put in place a process that would lead us to be in a better position to assure ourselves of that.
But that's not what it says, Dr. Studdard. Consequently, care recipients are placed at immediate and severe risk. That's a non sequitur.
I can agree with you on the grammar. I guess it would be more appropriate that it said are determined to be at immediate and severe risk, and that is how that is.
All it's based on is the proposition that the deficiencies that are identified seriously undermine the provider's ability to properly provide care. Not that it isn't providing the care.
Well,
And
That
if
may
that's
be the
right,
case,
if
but
that's right,
we don't have a way of determining that.
if that's right, the final sentence simply is not supportable.
Well, I think that, as I said, in the absence of anything to advise us otherwise, the default position is to put in place a process that would lead us to determine that that was not the case.
Well, that may all be right, but it doesn't justify the final sentence upon which all else hangs.
Well, I think the system is there to provide the assurance that care recipients are getting the care they need.
Well,
And
that
the
may-
documentation and the systems that the provider has in place assure that both to themselves as a provider and to us as the regulator.
Well, that may well be right, but it doesn't answer the point that I put to you, that there is no evidence in this report or any of findings made in this report that support that final sentence.
Well, I think there's a range of documentation here around care recipients' files that don't contain the specifics of service delivery, that the provider wasn't able to demonstrate that assisted care recipients have a care plan. And I guess our position, and this would, I would suggest, be based on many years of experience in assessing risk around aged care, that the absence of that would give great cause for concern.
It may well, but it doesn't warrant that final sentence. Yes, Dr. McAvoy.
Just on the subject then, Dr. Studdert, of many years of experience being deployed in the assessment of this situation, you might recall before lunch I asked you about whether it was ever the case that the former agency, now the Commission, and the Department are likely to be in disagreement or apart in relation to particular matters. And I think your answer in substance was that you thought that was quite unlikely. Yes. You agree with that?
Yes.
Yes. Operator, can you bring up CTH 4000, stop 1003, stop 2096? Now, are you familiar with this document, Dr. Studd? I imagine you are.
Yes.
This is the assessment contact advice provided by the former Aged Care Quality Agency in relation to BD Proprietary Limited. And it lists there, you'll see on the first page, the various problems that we've already traversed. And if you go to page 2, operator, you'll see there that heading improvements. Mm-hmm. This is what the agency thinks needs to happen. There needs to be a revised plan for continuous improvement submitted by the 30th of November showing how the home care standards will be met. There are improvements which must be made in order to meet the home care standards. The timetable to do that ends on 31 January this year. If at the end of the timetable the service doesn't meet the home care standards, we'll advise the Department of Health. So there's no serious risk report issued or required to be issued, it would seem, if you ask the agency. Am I wrong about that?
Well, this report was referred to the department in short order. Mm-hmm. And I believe that was done with an accompanying serious risk report, but I'm just reviewing it. But just to note, the system is such that these improvements are what the tools that were available to the agency and now the Commission in terms of their engagement with the provider, and then their obligation is to refer it to the department for the department in its role and its assessment of what the information tell us as to what this means, and the more fulsome report has a lot more detail, of course, around the unmet, what underlies each of those unmets, and that is where the determination around serious immediate risk is made. So this is completely consistent with what the levers are that the Commission has versus those that the department has.
But the reaction of the agency, you'd accept, is rather different to the reaction of the department, wouldn't you?
Well, this isn't the only reaction of the agency, though. The other action that they took was to refer that in a short time span to the department, reflecting their level of concern.
They did, yes, yes, and the department did what it did, and I've taken you to that, and you've fully embraced that. But isn't it the case that the agency has taken a rather less extreme view?
Well, as I said, these are the levers that the agency has in terms of how it engages with the provider, and it's a two-part system.
I don't really understand, Dr. Stoddart, why you won't embrace the proposition that there is a clear and obvious difference between the agency's approach and the department's approach.
Well, I guess I'm not sure what you're suggesting the agency would have done had...
I'm not suggesting anything. I'm not suggesting anything in that respect. I'm simply observing that the agency says one thing and the department says another. Isn't that a fair reading?
But the agency has said that you've not met 8 out of 8 outcomes, and our engagement will be to tell you how our expectations of what your program to improvement is, timetable for improvement is, and at the same time, whilst not documented here, that they will be referring that to the department, where it is the department's role to make that assessment as to what that means around risk to the care recipients.
But the agency hasn't found that there's a serious risk.
That's not their role to do so.
They haven't said anything that would indicate that there is anything like that order of concern.
Well, I guess it may not be there in the words, but 8 out of 8 unmets is a serious issue.
Why don't you say it's not their role to say anything on the subject of whether there's a serious risk?
That's the role of the in the system. That is the role of the department to make that determination.
I'm getting the sense that Mr. Speed's wanting to say something.
The delegate within the department will consider the advice that comes to them to make a decision around non-compliance, including a sanction decision. The delegate will use the initial risk assessment and the detailed risk assessment template that we reviewed earlier to arrive at their decision. And in arriving at their decision, they'll consider the information that's provided to them by the Quality Agency and a range of factors.
So it's the position of both of you, is it, that there's no asymmetry between what the agency has had to say and what the department has had to say?
No.
There is no asymmetry?
No.
No.
In as much as each part of the system is playing its role and doing it within the prescribed processes and guidelines that they are there to play.
And you remain of the view that this is an extraordinary case.
That's correct, yes, because if I may, these clients had already been, for the most part, been with one provider that had been sanctioned. They transitioned to another provider, and now we found ourselves in the same position, still without documented care plans that gave us, as the department, any confidence that they were getting the care they received. So it was an extraordinary circumstance.
Commissioners, I don't have any further questions.
Well, could we leave that document on the screen, please? I think this is probably one for you, Mr. Speed, but you've read this document?
Yes, I have.
Do you regard that as an adequate notice to somebody who was found to be non-compliant?
It is a advice to the department, and it was provided in relation to a range of information that was released to the department by the Commission.
You didn't answer my question.
Could you repeat your question? Sorry.
Do you regard this as an adequate notice to somebody who has been found to be non-compliant?
I regard it as an early release piece of information, adequate notice, yes.
That's the second time you haven't answered my question.
On the face of it, on the information that's contained in it, it would seem to be no.
Well, you see, improvements are required as a result of deficiencies. None of the deficiencies are particularised. All that's happened is a series of quotes from the manual. There is no indication to the provider as to how the company has fallen short of those standards, and yet their
If I could...
replacement, I beg your pardon, rectification is being required of them.
If I could, Commissioner, as Mr Speed just said, this is just one of the documents that is provided.
Well, what else did the provider get
And this
at this time?
This was actually provided to the department. So this document was actually provided to the department. It was not.
Not to, well, I'm sorry, I don't understand how, why would a document that talks about improvements addressed to BD Proprietary Limited be a document that was sent instead to the department?
Well, Commissioner, before the witness answers that question, can I just indicate to you for your information that that document we're talking about was sent to BC on the 19th of November 2018.
But earlier to the department.
Yes.
And it was accompanied by, if I could, the Home Care Assessment Contact Report, which is the 19-page document, which has the more fulsome description of how each of those unmets were
What
determined.
19-page document are you referring to?
Are you referring to the assessment contact report,
Yes.
Dr. Stoddart? Yes. Operator, that's CTH 1002 stock 1001 3863. That's the document you want, Dr. Stoddart?
Yes.
Yes, and that document was sent together with the other one, is that right? To BD Proprietary Limited?
If I may, the advice is sent to the department, and the contact report would have been sent to the BD as well as the department.
Yes, so I'm just trying to put myself in the position of the provider who is dealing with the agency and the department at the same time. There are allegations being made that the relevant standards have not been met in particular ways, and that they must, according to the agency, be rectified. And there's a time limit for that rectification process that's been given. And in order for that to occur, the person must understand precisely what deficiencies there have been that have led to this position, so that the rectification can take place. Now, the opening words of the previous document that we were looking at say the assessment contact report, which is this other document, provides details of the assessment team's assessment during the assessment contact. So we then go to this other document, which I assume is then also sent to the provider. Is that right? Yes.
I believe so, yes.
Yes. And is there anything in this contact report that suggests in any way any deficiency in the provision of clinical services to any of the people for whom services are being provided?
Commissioner, there is a lot of detail in this report, and I think I would say, to answer your question, I would say yes.
You'd say yes. Well, I've read it and I can't see anything. So I'd be grateful if you would point out to me, please, anything in it that directly suggests that there are any deficiencies in clinical services. I can see there's a complaint about a light bulb that hasn't been removed or replaced. That's not what I'm talking about.
Well, Commissioner, I mean, as I've said earlier, I think the itemisation of the care recipients with blank care plans, and these were recipients that had been, in some cases, of quite high needs, level 4, and had been in care with either the previous provider and this provider for some months, was, as I've said, a cause for concern.
Well, it may well be, but would you agree with me that it is perfectly consistent with a failure to do the paperwork for high-level care to be actually being provided?
But if there's no paperwork that actually says what care each individual needs...
You're not answering my question.
Well, I accept that there's nothing here that says care is not being provided.
No, well, no, the question was, conceptually, there is nothing inconsistent with a failure to document a care plan and the actual provision of high quality care.
I guess I find it hard to accept that there could be care being provided consistent with the client's needs and assessed needs to the level that would be expected if there's no documentation.
Well, that's just an assumption. That's not an answer to my question.
Okay, I mean, I accept that's an assumption. I think in the case of the assessors, that would be one that's made on some basis of experience and engagement with a range of providers and clients over some many years.
If I might pick up on that, Dr. Studdert, I think the issue about if you've got governance problems, you may well have care problems is something that I think we probably appreciate. I think what we have heard in evidence and submissions and so on to this Royal Commission is that there's a lot of process in this system to assess quality of care, but there's not much eyeballing of or review of the quality of care itself. And so the care plan, being in the written form, providing a process, has become a substitute for an actual review of the quality of care being provided. And that's the challenge we're facing here, because in the evidence we heard yesterday, we couldn't see or hear that there wasn't very good quality care being provided by a very caring workforce. So where I'm going with this is to try and understand whether you believe that the care plan is sufficient to assess that there's quality of care.
So I would accept it's not sufficient in and of itself.
Mm-hmm.
But I would contend, as I guess I've been trying to, that it's a necessary first step.
Right. I hear that. Can I ask another question about sanctions more generally? in a case where another provider was sanctioned and their beds or their care users of packages or whatever were then taken over by another provider, what's the sort of expectation and the time frame for taking that those services to a higher level that actually meets the standard? Does it vary according to size, or is there a general expectation that within a period of months you will have complied with the sanctions, complied with the rules?
If I may, the general period for a sanction is around 6 months.
Right.
It can vary, can be up to 9 months. And there's the expectation that within that period, the provider, be it residential or home care, will have returned to compliance.
But I think your question was to this situation where we've transitioned clients from one provider to another. And I think these are fairly unique, well not unique, but unusual circumstances in our experience to date. And that would be, I think, fair to say, done on a case-by-case basis, but with a lot of attention from the Commission and the Department in that time, and that would essentially aim to do that as soon as possible.
Right. Is the Department doing any work at the moment to assess more effectively the actual quality of care being delivered?
Yes, it is, and I think it goes to some of the earlier questions and comments that we provided, that this is, by its nature, a very dispersed business, and the capacity of the system to, as you said, eyeball every client is going to be limited. And so the ways to do that in a efficient but effective way, but one that also takes into account the particular circumstances of the clients in their home setting and the necessary privacy, access issues that come with that, are ones that we have to continue to develop, because that is not something that is, I don't think it's fully developed in the context of the growing system that we have. And that is something we are working on, yes.
It might be useful if you provide us the information about how you're seeking to develop that system of quality clinical care.
And we would do that in conjunction with the Commission, because that's also, of course, a very big part of their work.
Thank you.
Anything arising from that, Dr.
Perhaps just one thing, Commissioner. Of course, Dr. Studdert, just in relation to BC and BD Proprietary Limited, the imposition of these sanctions was in early November last year, a couple of weeks after the calling of this Royal Commission. There wouldn't be a sense, would there, in which the Department was wanting to make an example of particular providers?
I would absolutely reject that premise.
Nothing further, Commissioner.
We thank you both for your evidence. We would be grateful if, as soon as possible, you could provide us with the matters that have been taken on notice, and we would also be most interested to know what the results of your researches relating to the treatment of Ms. Kurnowski have been. Thank you both very much.
Now, Commissioners, we now have Professor Swearson. I'm very conscious of the time. However, if the Commissioners are disposed to sit for a little longer.
Yes, we're happy to sit on and take this additional evidence.
Thank you. If Dr. Swerson could call.
You might be excused, Commissioners. Thank you.
That's an order. Thank you.
I solemnly and sincerely declare and affirm
I solemnly and sincerely declare and affirm
that the evidence I shall give
that the evidence I shall give
will be the truth,
will be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Operator, could you bring up WIT stop 0085? Yes, thank you. Professor Swerson, you've provided a statement to the Royal Commission, which I think is there on the screen. Is that correct? And is that statement true and correct to the best of your knowledge and belief?
Apart from the odd typo, yes.
We'll give you the typos. Commissioner, could I tender that statement and the annexures to it?
Yes, the statement of Professor Swerson and the annexes to it will collectively constitute Exhibit 2/86.
Professor, could you give the Commission your full name?
Yelmar Swerson.
And what are your professional qualifications?
I have professional qualifications in psychology, business management and organisational theory.
And what's your present professional role?
I'm Emeritus Professor of Public Health at La Trobe University, and I'm a visiting fellow at the Grattan Institute.
And what's the Grattan Institute?
It's I think what people would colloquially call a think tank, and its principal purpose is to assist in providing good public policy in the national interest or in the public interest.
And does it receive ongoing funding from government?
No, the Grattan Institute is funded by a bequest which was made, an endowment which was made some time ago, and it receives no public funding, and it also receives no funding for the research work that it does on a contract basis.
And what's the Institute's research interest in aged care?
We have a health program which has done a number of reports, some of which I've listed in the statement, and the Institute is exploring long-term care at the moment as a research area, and that includes aged care, disability and probably mental health. We haven't decided on the exact parameters of it, but we are certainly interested in aged care at the moment.
So from about paragraph 8 of your statement, you set out major areas of concern in the delivery of aged care, particularly in the context of home care.
Mm-hmm.
How would you say Australia is travelling in its development of aged care policy?
I think Australia is probably best described as being in a period of transition. The directions have been there for a while since the recent reforms, and so we're moving from a system which was heavily dominated by essentially provider-based funding to one which is much more focused on consumer-directed funding. But it hasn't quite moved to a fully operational set of arrangements for consumer-directed funding, and it still has a set of issues which are to do with the split between residential and community care, which I think I've outlined in the statement later. The other thing I'd say is that as a result of the transitional arrangements, the Commonwealth has increasingly taken over responsibility for aged care, and that's left some gaps operationally and in a systems management sense. it's probably created some difficulty for consumers accessing services as we've centralised the arrangements with the Commonwealth. There are a significant set of issues with the transition, that there are now different funding mechanisms for different parts of the system, and they're not well aligned, and so they'll need to be addressed if we're going to see more portability of care. I think there are some anomalies now between, for example, the disability legislation and the aged care legislation in terms of the framework and the arrangements which have been put in place, so that long-term care is being seen differently in different parts of for different populations. And I think that those issues are there because it's a very large-scale set of changes which are required, and so inevitably there is a period where it needs to settle.
How does Australia compare to similarly placed countries in the OECD in relation to its aged care spend?
Well, Australia, the short answer is we're probably a little less than the average on the OECD. We spend about 1% of GDP, so GDP is roughly 1.8 trillion. The Commonwealth spends about 1.8 billion, so that's roughly 1% of GDP. The OECD probably spends roughly 1.4% of GDP on average. There are some issues about comparability of data, but that's the sort of general picture that you'd see. The situation in Australia is that we probably have slightly more residential care being provided to older people, and slightly less community-based care than you would see in the OECD. If you look at the sort of leading countries in the OECD in terms of spending, you would be looking at the Netherlands or Sweden, and they spend probably in GDP terms 3 times as much as Australia does.
One of the observations you've made in paragraph 8 is that we overemphasise spending control to the detriment of service access and quality of outcomes. Do you want to enlarge a bit upon that complaint?
Yes, I can. Inevitably, government is faced with the problem of fiscal constraints. So with a large spend like aged care, which is in the order of $18 or $20 billion, governments seek to manage that, and the choice you have is really, as government, do you make that a universal system with relatively open access and then really manage the overall budget, or do you cap the budget? The aged care budget is capped, the Medicare budget's not capped, the PBS budget's not capped, and they're managed as soft caps, which means that you try and manage it, but you don't absolutely constrain it. The disability legislation has moved towards essentially a soft capping type of approach, which is much more open-ended, meet the what are called the reasonable and necessary needs of people with disabilities. The aged care legislation is much more concerned about actually putting in place systems of assessment, classification, and the mechanisms for controlling the overall spend in the aged care system. So if you look at the two pieces of legislation side by side, you'll see that there's an enormous amount of effort in the aged care legislation focused on assessment, eligibility, the management of the money. And you look at the disability legislation, you see there's an enormous amount of effort put into how do you do the plan for people with disability so that they get the services that they actually need. Now that's quite a difference in philosophy for the two systems, and that's an indication that there's some transitional issues going on in our thinking about long-term care.
Another of the observations you make in paragraph 8 is that over time the planning, organisation and management of aged care has become overly centralised. Now that's a criticism that's been made by others that we've heard. What do you have in mind particularly when you say that, and what would you regard as the alternative?
So what I have in mind when I say that is that the Commonwealth quite understandably has brought in a national approach, national funding arrangements, national waiting lists and waiting times that follow from that, which are national. It's set up a system with My Aged Care, which is essentially a portal, which is a national portal with a telephone line that goes with it. The alternative is to have a system where you have national functions and responsibilities, but you also then set up an integrated, a sensible set of regional or area-based arrangements which are responsible for managing the system, which provide clean access for people, where people, within reason, localise the arrangements to suit circumstances which actually apply, and they're quite different in North Queensland than they are in metropolitan Melbourne. And that in that sense, you have to have an approach which says, well, let's sort out what the relevant functions are locally and what are the relevant functions at the national level. And there are some which should be done nationally and there are some which should be done much more locally. And because the Commonwealth has taken over these responsibilities, local government has dropped away, and so have the states. And the states typically have been the systems managers in the past, always a bit fractious, but nevertheless that was partly their role. They've moved out of that space, so has the local government has increasingly become a service provider rather than a co-designer of the system. And the result is that we've got a bit of a vacuum emerging in the local management of service systems. And there are basically internationally there are two models for dealing with that. One is you organise things on an area basis. You take a population within a given catchment and you say, well, this organisational entity is responsible for ensuring planning, governance of the service system, making sure that things actually work locally. Or you have a population enrolment approach where you can have, you're not so worried about the area as the organising the region or the geographic area, and you can organise things on the basis of people enrol with a particular insurer or a particular agency, which is more like the United States in terms of its healthcare system of enrolling with particular health insurers. Now, Australia has traditionally used area-based models for organising services. They've regionalised, and the most obvious one is states. But the Commonwealth's moved into that space and it hasn't sorted out an arrangement at the local level for how this is to be done.
And you would say that an arrangement at a local level is of very great importance?
Yes, I do. I think the two things that matter. One is you need a place where the consumers, people have talked about having a gateway or a portal and so on, and that needs to be localised and it needs to be consistent in the sense of bringing things together. You need to bring assessment, planning, coordination, the management of the actual person's needs, and they can still be consumer directed. People can make choices, but somebody needs to be there that they can go to at the local level. And the other part of it is that an individual consumer can't manage a service system. If there's a gap somewhere in Gympie or Bort, the reality is the individual consumer can't actually fix that. So there needs to be somebody who's accountable for saying, okay, we've got a gap in the service system, how shall we fix that at that local level? And that becomes then a matter of managing that service system so that there are services for people to choose from. That's called, usually people see that as managing the market or actually doing service system planning and nudging the service system in particular directions. You don't have to do that in a Stalinist way. You can do that in a facilitating and nudging way to get what you need. So I'm not arguing for going back to some sort of a Soviet approach to these sorts of things, but I do think there needs to be some agency in the system that deals with these issues. Otherwise you're trying to deal with it all from Canberra basically, and that's very difficult because you're a long way away and you don't have relationships. And the experience in other places trying to do this is that having these highly bureaucratic administrative arrangements lose the sense of the relationships between the players at the local level and the management of that system in a more sophisticated way. You end up doing it all by basically administrative fiat or trying to deal with it in a very transactional way. And if you look at the literature on that, those transactional approaches tend to have difficulties, particularly in systems in transition and where the arrangements are fuzzy, where you've got, where not everything is yet sorted out.
This is a classic subsidiarity model.
It is a classic subsidiarity model. And you can choose various options for the subsidiarity. The problem in Australia at the moment is that we've moved the states out of it, and the states have said it's the Commonwealth's responsibility, and the Commonwealth needs to make some choices about what subsidiarity model it wants to develop. I've suggested that there are some options for that, so the important point is that unless that gap is filled, there will continue to be difficulties.
Well, why don't you walk us through the options that you've identified?
So one of the things that the Commonwealth's done, and I have to declare a conflict, is to set up primary health networks, and I actually sit on the board of one of those, and there are 31 of those nationally. The reason the Commonwealth has done that is...
Do you want to just explain, for the benefit of the Royal Commission, precisely what a primary...
Yes, I will. So a primary health network is there are 31 primary health networks, and their job is to bring together the general practice system with other allied health and the acute hospital system. And increasingly, they've also had a role in long-term care. So they've been asked to do mental health more recently. The Commonwealth now funds mental health through that. The primary care networks are independent of service provision. They don't do any service providing. They only commission services. And they do the planning for a region, so there are 31 of them, so they tend to have populations of about 1 million people, roughly 600 to 1 million. They have probably $1 billion a year being spent. I haven't looked at the numbers recently, but it's a significant organisational infrastructure, and it does this management of the relationships between agencies and the planning. It provides information to the community and so on. And there is an opportunity to leverage those arrangements to start to see some of this happening in terms of the subsidiarity model. The other option would be local government, but local government is very different in different states, and it has the problem that it provides services, so it's difficult for it to be separated out. You could go back to a Commonwealth state negotiation and let the states do it, but we've been down that path and the states have moved out of aged care, so that would be difficult to do. You would need to, whatever model is brought in, you need to bring in that subsidiarity model the Commonwealth role, the state role, and local government role back in, but with a broker, so that you start to sort these quite difficult service delivery issues out. The other thing that I would do is I'd bring things like the consumer and respite care function, which is currently being done by the Commonwealth, into that kind of model, so that information and access was there. I'd bring the aged care assessment services into that sort of a model, so that they've got a coherent home that they live with, and I would start to integrate these functions at the local level. I'd leave my aged care in place for those people who want to use it, but it would be supported by a coherent structure at the local level, so that in fact you would be able to see these things happening. Now the Commonwealth's thinking about these sorts of things, but inevitably the Commonwealth always runs these little trials, so it's got a navigator trial out there at the moment, and so we'll see how that goes. It needs to think a bit more systemically about these issues than simply let's have yet another grafted on function. It needs to say, okay, we, the Commonwealth, need to recognise we have functions that we should do, and there are some things that should be done more locally, and we need to sort out how we're going to do that.
You'll be aware that since the start of the Royal Commission, the government's announced an additional 20,000 home care packages.
Yeah.
What do you think is likely to happen as a result of this? Do you regard this as being a sufficient injection into the system?
It's welcome, but it's not enough. Well, you well know, I think, that there are 130,000 people on the waiting list at the moment, and there are significant waiting times for that. There are two priority queues running, one really allocating people quickly as possible to a lower level of package, and then another one which is running more slowly beside it. I think the reality is that putting more packages in is a good thing, and I support that, but really there needs to be some reforms to bring that funding system into a more organised space. One of the things that's a problem is that we've bundled funding around accommodation approaches. So we've bundled funding around home and around residential care, and it would be better if we separated those funding streams and said we need a funding stream for care regardless of the accommodation setting, and that could then include all the things that you would normally think of as care services, and a funding stream which is more focused on supporting accommodation needs. That's facility charges, you know, what people sometimes call board and lodging, and the capital costs associated with care. Then if you do that, then it becomes easier to move people to take their care funding to an accommodation setting that's sensible, rather than being limited to either home or residential care, so that they can move to supported accommodation. So for example, the Swiss have a model where you have supported accommodation, which is more like what we would call villages, and you can move care into that village because you have portable arrangements. If you have things which are only sort of linked to a home care package or a residential care arrangement, then they're the choices you've got. Whereas if you've got a more flexible care package, you can move that around. You then have to sort out what is in the accommodation side of it, and there are some choices about that. So I think the fundamental issue will be that on the other side of that is that we've got this split between basically home support, which is entry-level care, and then more complex care, and that creates a set of disjunctures as well in terms of moving from one to the other, and then what happens if your needs change up and so on. So it would be better to bring care funding into one stream and accommodation type funding into another, and then start to flex that up so that you allow basically not to cap that, but to allow it to flex up and manage it in other ways, manage the overall quantum of money, if that's what the Commonwealth's worried about, in a more sophisticated way than simply saying, well, there are only this many packages.
Can I ask you to turn to the issue of increasing user contributions?
Yes.
What do you say about that?
Increasing user contributions? Well, we need to make a decision, really, I think, about what is the reasonable balance between user contributions and other forms of funding, either insurance-based funding or taxation-based funding. And what are the principles that we're using for user-based? So at the moment, the principles are largely equity-based, so that you essentially say people on low incomes will be protected in the scheme. And there is a set of arrangements which say, well, we should essentially have a board and lodgings charge. And that may well be reasonable, but we have some discontinuities in that at the moment, which, for example, on low-level packages of care, if your means are a bit too high, then the package becomes essentially, well, you're basically paying for it yourself. So we need to make some choices about that. So that needs to be streamlined. I think probably that the sensible approach is to say board and lodging is your responsibility. It would be your responsibility if you were living independently of any services, so why would it be not your responsibility in some form or other? And then protect very low income people in terms of accommodation charges, so that they don't end up, particularly people, for example, who are homeless or who have insecure housing and so on. And then the care, we can have a different kind of user contribution arrangement for that, the care services, and that we need to make a decision as to what we do. So some places like France have very steep means-tested arrangements for that. Japan started off with a 10% charge on care, then moved it up to 30% as it got more expensive. We need to have a discussion as to what we think the principles are for dealing with that. It's become a bit messy in terms of the various contribution schemes that are there at the moment.
Well, I was actually going to ask you about Japan, which you discuss in paragraph 44 of your statement, as being perhaps a place where they've got it reasonably well set up. Mandatory insurance schemes, how they do it, as I understand the position from your statement in Japan.
Yes.
How is that done?
It's essentially so the Japanese experience was up until about 2000 there was virtually no essentially people were responsible for their own long-term care, and so it was there were very many people clogging up the hospital system because there was not many other places to go. So they had very long stays in hospital as a result of people not having a long-term care system. So a long-term care system was legislated in '97 and introduced in 2000. The initial approach was essentially to say about half the system would be funded through general taxation and the other half would be funded through social insurance, basically. And there were two parts to the social insurance scheme. One is that people over the age of 40 paid social insurance in anticipation of their potential aged care needs, so it pooled the risk. And people, and then there were two parts to that. One was how you were paid before you retired, and then there was one part after when you were over 65, what would happen. That was brought in, and then there was a 10% user charge. Just if you got services, there was a 10% user charge. The Japanese then built a system which was very heavily based on the idea of local coordination centres. They put 4,000 local coordination centres in place with the sorts of things that I was talking about earlier. And they then ran it, and they've had a series of modifications to tweak it since then. But that's probably the most it's one of the systems which has had the biggest change over the last 20 years, going from a very different system to something new. So there's a whole lot that can be learnt from what happened in the Japanese experience.
Why has it been so popular in Japan?
I think because people didn't have access to services before that. They worked very hard on getting community support for it. So if you go out into Australia and say, well, I think we should have a significant increase in general taxation, people would go, that's not such a great idea. If you go out and say, I think we should have a dedicated taxation arrangement or insurance arrangement, social insurance arrangement for long-term care or for aged care, then people are much more likely to say, well, that sounds reasonable given the sorts of things we've been hearing about aged care, so we would be prepared to see additional funding going into that. The way that was done for the disability scheme, of course, was to increase the Medicare levy, to see additional funds come into the system. My view is that unless you have additional money, we'll be here again at some point in time, having a discussion about quality of care, lack of a workforce, the sorts of issues there. That will always happen. The other part of the thing, which isn't so much the money, is if we don't reorganise the local arrangements, we'll be here again, because you can't run everything from Canberra. You have to have something at the local level. So those are the two major systemic issues that have to be addressed if you're going to start to address these, the concerns that we're hearing about quality and access and fragmentation and so on.
But there's got to be a way to control the spend, doesn't there? I mean,
Yeah.
if you're going to have a plan-based funding model, what do you do about controlling the spend?
Well, there are two main ways of controlling spending. One is price and the other is volume. And we've got a lot of emphasis on volume at the moment, who can get access to a package. The other thing you can do, of course, is have a much more managed schedule of costs, so that you effectively say in the plan there's a schedule of costs and you can only charge those costs. You set them as maximum so that people can compete going down on those costs, but you then have a schedule. So what we've got at the moment is an assessment arrangement where you get assessed for eligibility, you get allocated to a funding category, and then you're off trying to figure out what services you need yourself, and then you sign a service agreement and all the things that happen. What probably needs to happen is a more organised approach to that service agreement being done by an independent broker as part of the arrangements, which the consumer, the older person themselves or the carers, negotiate. And then there's a schedule of fees. So you say an hour of personal care in the morning is worth this, and you can't charge more than that, and so on and so forth. And you manage the costs by actually managing the cost schedule. And then the other thing that's really important in that is what's happened in the disability scheme is the concept of necessary and reasonable, and that needs to be a negotiated arrangement, so that I shouldn't just be able to go out and say, well, I've got a set of needs and I think I need these things, without having some sort of negotiation about that being necessary and reasonable with a sensible planner. That's a reasonable set of arrangements which is adopted in other places. So I think that that's how you manage costs. Instead of it being these hard barriers, you do it on a more nuanced basis. What's happening at the moment with these costs that we've got a series of difficulties with the ACFI in the nursing home world, which I'm sure you'll get to at some point, and there's a series of difficulties with the 4-level arrangement that we've got with the community care arrangement, where we've got $350 million of unspent money at the moment, because we allocate the money and then the services aren't properly planned around the individual. If you plan them around the individual, then they would get what they needed for their plan. There wouldn't be any unspent money.
So when you talk about this, are you really talking about the imposition of price caps for services?
I'm talking about having a negotiated set of prices for different types of care, so hours of nursing, hours of personal care, what Allied Health gets, and so on. And then the hours are negotiated in the plan, and they have to be reasonable and necessary, and so that's a managed system so that you don't end up with just Rafferty's rules. But that requires a rethink on how things are done at the moment. At the moment, the capping is done by just allocating an amount of money per person and saying, now it's over to you to spend it. And that's a different model of how you manage those costs.
Look, for present purposes, Commissioner, I don't have further questions of Professor Sverrisson. His statement is very comprehensive. It may be that we need to hear from him again in relation to particular aspects of what he proposes.
Is there anything you want to ask now? Professor, thank you very much for your introduction to many of the issues that we're going to have to grapple with as the year goes on. As Senior Counsel has just indicated, I think it's more likely than not that as our ideas become more formulated, we may be calling on you again, perhaps not in a formal setting like this, but at a round table, just to air options with you and see at a policy level what is the best scheme for this country in an area of enormous concern to more and more people as they get older. But thank you for introducing us to your research and suggestions, and we are very grateful to you also for agreeing to stay on late today and give your evidence at a time where you might rather be elsewhere. Thank you very much.
Thank you very much.
Dr McAvoy, 10 o'clock in the morning?
Thank you, Commissioner, yes.
Yes, very well. The Commission will adjourn until 10 a.m. tomorrow morning.
All stand. The Royal Commission is now adjourned Friday, 22nd of March at 10 a.m.